Okay, good morning, dear colleagues, dear friends, dear guests. Please take your seats so that we can start. We are having really a busy and long agenda today, so to treat everyone equally, to give enough time also to a debate we would like to have, I would like us to start today. Let me start with the language regime, which is active, so you can speak and listen to French, German, English, Italian, Spanish, and Polish. No additional passive languages, so please use these languages so that we can, as usually, use the potential of the interpretation we are having available. So, colleagues, friends, good morning to everyone. And also distinguished guests, we are having quite high-ranking participants today of the different panels, although some are just video messages. But I mean, the topic is so important that we really need to go into that. I'm extremely happy to have Esther with me because this is a co-organized event of the EESC Workers Group and the ETUC, which we try to do regularly, on the topics which are of the interest of both of the organizations, to be able to equip ourselves, our members, ETUC members, with the expertise and knowledge to be able to face the different challenges on the different issues we are having. So, on behalf of the EESC Workers Group, it's my pleasure to welcome you here today for a session of the Workers' Voice category to discuss the Commission's proposal for the so-called 28th regime and the creation of the EU Inc. So, special welcome again to our colleagues and guests from the ETUC, and especially Esther. I'm so happy to have you here, Esther. We are here to discuss the issue that is central to the future of workers' rights, employee participation, and responsible corporate governance in Europe. The 28th regime is a proposal that could have far-reaching consequences, not only for companies, but also for the millions of employees whose rights and protections have been hard-won over decades. We are in a context when the Commission presented this proposal on the 18th March 2026, intending to introduce a single EU-wide corporate form, the EU Inc., with the stated aim of promoting startups and innovation. On first sight, it looks like a progressive initiative to support cross-border business and more integrated European market. However, our early assessments highlight serious concerns. From the perspective of workers, the current design of the EU Inc. is not acceptable. It risks undermining national protections for creditors, consumers, and employees, and it could weaken co-determination systems in 18 member states. Let me outline our key red flags. First, the legal basis chosen by the Commission, Article 114 of the Treaty on the Functioning of the EU, is inappropriate for creation of a completely new corporate form alongside national law. Expert opinion and ECJ case law confirm that Article 114 is intended for harmonization, not the establishment of a new type of company. The correct legal basis would be Article 352 of the treaty, which requires unanimity in the Council, ensuring legitimacy and respect for member states' competences. Second, the structure of the EU Inc., with the potential separation between the registered office and the actual management seat, would allow companies to evade national co-determination rules. Workers' participation rights would follow the registered seat, not the location where the management decisions are taken or where workers are employed. This creates a clear risk of evasion of existing legal protection and obligation. Third, the EU Inc. as proposed has no minimum capital requirements and allows online-only formation without proper identity verification or oversight. This opens the door to letterbox companies, fraud and misuse, while transferring all risks to employees, consumers, and the public sector. These are not hypothetical risks. They have been highlighted independently by the ETUC, Union Europa, and national trade unions. Workers' organizations across Europe see this proposal as undermining protections and opening a race to the bottom in corporate standards. Even the start-up community, supposedly the primary beneficiaries, has expressed concerns about the feasibility and credibility of the EU Inc. So today our aim is not simply to criticize. It is to engage, to analyze, and to identify solutions. In this morning's sessions, we will hear from our rapporteurs, legal experts, and representatives of the European Commission, the ETUI, and members of the European Parliament. We will examine why the bells are ringing and how the proposal could be adjusted to truly protect workers, support responsible innovation, and strengthen the single market without undermining social rights. I invite you all to participate actively in the discussion, to ask critical questions, and to share your perspectives. Only through open dialogue and collaboration can we ensure that any new European company form safeguards workers' rights, prevents abuse, and contributes positively to the European economy. So thanks for being here, and I definitely look forward to a productive and engaging session. Thank you, and Esther, the floor is yours.
Thanks, Lucy. Good morning, and really want to thank Lucy and everybody who's worked on putting the programme together today. It's a joint initiative. We've started to do these a couple every year, and I really think it's so important for us to come together to have an opportunity to think about what the proposals mean in practice, but exactly as you say, Lucy, to think about how we're going to respond. There are going to be three major myths that everybody's going to be facing into when we come to discuss this. The first major myth is this is a great idea for young people trying to start up their business. No? Whereas we know this is not about anything but startups. This is about venture capital. All of the money behind EU Inc., and it's substantial, all of the money behind EU Inc. is from venture capital. It's not, the proposal doesn't just apply to businesses that were established in the last 6 months or a year, nor does it apply to small businesses. It applies to any company whatsoever. That anybody who chooses within 2 days with no capital to open a business. Now, everybody who knows about cowboy builders in the construction industry can immediately think about all of the use that they will put to that. So the first big myth, it's not about helping young people with startups. Second myth is we've no reason to be worried because it already says it doesn't affect employment law in the recital. In fact, President von der Leyen told a delegation from trade unions exactly that, and I've no doubt that when we see the video from Commissioner McGrath, he's going to attempt to tell us the same thing. Now, the reason this is challenging is because quite a few people who are on our side have said that to me, that they don't, that, you know, this is all solved, that the intention isn't to impact on national employment law. So we have to be very clear in how it will impact on national law because the appropriate safeguards have not been included. And I'm very happy that in the programme there'll be quite a bit of discussion about that. So I think that we're going to have a good day because we're going to deep dive into how we prepare ourselves with the right arguments, with the right analysis, and how we begin to push back and either stop this proposal completely or if not, if we can't stop it completely, to work very, very hard to try and reduce the negative impact of it. And I'm very happy that the European Parliament are going to be part of our discussion today, because we need to take a sounding from them too. So, Lucy, back to you for the first introduction of the first person on the panel.
Thank you very much, Esther. It just shows how complementary we are, and I'm extremely happy for that. So let us start with the in-house, basically outputs, which I'm extremely happy we were able to deliver. So the rapporteur of the opinion on the 28th regime, Maxi Leuchters, our member. So Maxi, floor goes to you for 7 minutes, please.
Yes, thank you very much for the invitation, and also thank you very much for making space and time to discuss this very important file also in this category meeting. I think it is very timely, and some of the relevant points have already mentioned by you. I would like to maybe, first of all, have a broader picture. And I think this also reflects on what we are discussing here in our committee, is that the EU is actually a social market economy, and that within this system there are different stakeholders which need to be respected and which are important actually when decisions are made within our committee, but I also think within the EU as a whole. And when you look now at corporate governance, this also should be reflected within corporate governance. And there are different things when you look at corporate governance, how it is structured on European level, but also on national level. You can see these checks and balances, this reflection of what a social market economy actually is within different rules and different laws which are established already. And from my point of view, this checks and balances reflecting these different stakeholders, which are affected by companies and which actually are basically the key actors also when working on growth. These stakeholders should also be taken into account when also drafting new laws. And it is kind of also a technical point called pluralistic company interest, so kind of like including these different actors when defining what's actually the purpose of a company. And these pluralistic company interest, not only including shareholder or maybe the interest of the founder, this is not an obstacle actually, but an asset in the EU. And when you now look at the proposal of the EU Inc., which is actually what we are discussing today, when you look at the proposal of the 28th regime, from my point of view, these different views, this different interest of the different actors is not reflected within the proposal. So when you now look also at different studies, when you look at the benefits of workers' voice, of workers' involvement within corporate governance, and there are different forms depending on the different countries, depending on the different member states within the EU. It's not an obstacle of growth or innovation, it's actually an asset. It's making companies more innovative. It's part of sustainable corporate governance, and this is why, from my point of view, it should be strengthened, as it has been actually the demand of different positions, for example, of the ETUC, but also of other European organizations, of different national federations of trade unions. It should actually be strengthened when we talk about innovation and strengthening innovation within companies rather than weakened. And the proposal actually at the moment has one article on workers' voice and workers' involvement, which is supposed to protect workers' involvement, but as Lucy already mentioned, it's actually the opposite. So due to the possibility to split the seat, so to have the registered office in one member state and the actual economic activity in another member state, there is the possibility for regime shopping, not only regarding corporate law, but also regarding the workers' involvement, as the workers' involvement and the workers' participation is actually dependent on the legal form. And in that case, when it is the EU Inc., the legal form and the corporate law, which is actually applicable, is then the corporate law of the member state where the EU Inc. is registered. So it's kind of technical, it's kind of complex, as it is a company law proposal, but it has consequences for workers' participation, for workers' involvement, and also for other stakeholders which have an interest within the company. You already mentioned creditors, shareholders, and also these stakeholders have the right that certain rules, certain checks and balances within a company are actually in place, so that their interest is actually also represented and that their interest is saved. And in Germany, we have some experience recently when it comes to bad corporate governance. Maybe you remember Wirecard, which has been a huge scandal within the German corporate governance. But I mean, it's also, an international scandal. There has been criminal activity involved. But this is actually why the rules on corporate governance have been actually increased. The rules companies have to apply within their own organization, more transparency and more rules on how the corporate governance is actually organized within the company, that these rules have been intensified. And from my point of view, this shows that rules, especially corporate governance rule, there are no, it's not a it's not something you want to, or you do because you want to make companies angry, or whether, or you don't do this because it's it's not unnecessary, but it is necessary in order to ensure that basically the functioning of the company and the different stakeholders where workers are a key component are actually ensured, that their interests are ensured, and also that the public is actually, that the public interest is actually ensured and very well represented within a company. So from my point of view, of course, we are in favor of supporting startups. We want to be very competitive within the EU, but this needs to go hand in hand with strong workers' voice, with supporting employees, because those are the people who are actually working on the growth within the company. And from my point of view, this proposal lacks this perspective. We need to ensure that actually the elements of the social market economy, the elements of sustainable corporate governance, which we have been working on also in this committee, are actually reflected in this proposal. And this, from my point of view, will be the measurement which I apply to any proposal and also, of course, to the opinion we're drafting at the moment. Thank you very much.
Thank you very much, Maxi, for this first introduction. We will get to some questions then later on. Esther, to you.
I'm going to introduce Antonio Garcia del Rigo, an economist, a Fulbright scholar, co-rapporteur here in the EESC on the opinion, having a lot of experience from two financial institutions, BBVA and Santander. And over to you now, in particular, the race to the bottom. What concerns should we have and how can we counter them?
Thank you very much, Esther, for your introduction. It is nice to see you here putting a face to the person who drafted the opinion of your trade union even before the proposal was launched. So I have prepared my intervention in English because all the documents are in English. So bear with my accent for a little bit. Let me start with a simple observation. Europe has a single market, but for companies, it still doesn't function as one single market. In practice, as you know, operating across Europe means navigating a labyrinth of 27 company law systems, each with its own procedures, costs, and administrative layers. This is not just a technical inconvenience. It is a structural weakness. It creates friction at every step of a company development, from incorporation to expansion to financing. And that friction matters. It is a barrier to scaling, to invest, and to competitiveness. Ultimately, it also has a cost in employment, in job creation, and in productivity. In fact, fragmentation is the single market increasingly acts like an internal tariff on European companies. It raises the cost of doing business across borders and limits our ability to operate and scale. The letter report explicitly cited as calling a single business code a game changer. This is a game changer. This diagnosis is widely shared. Businesses across Europe consistently point to fragmentation and administrative complexity as major obstacles to growth. And this is precisely what the EU Inc. proposal seeks to address. EU Inc. should be understood for what it is, a market integration tool, not a deregulation tool. It doesn't remove rules, nor does it weaken standards. What it does is remove unnecessary friction between national systems by creating a European option that is simple, digital, and usable across borders from the outset. By applying principles such as once-only registration and by reducing duplication, it aims at making cross-border activity workable in practice, not just a theory. This is particularly important because Europe has a well-known scaling problem. Companies can be created here, but too often they struggle to grow across borders. Each additional market introduces complexity, cost, and uncertainty. Investors face the same fragmentation. The result is predictable. Companies expand elsewhere. Capital flows elsewhere, and Europe underperforms. Against this background, we are also seeing a broader shift in European economic policy. Even in competition policy, there is a growing recognition that European companies need to achieve a scale in order to compete globally. But enabling a scale is not only about allowing mergers. It also requires a legal framework that allows companies to operate efficiently across borders. In that sense, we see EU Inc. This is not as an isolated initiative. It is the company law counterpart of a wider shift in European policy, fragmentation towards integration and towards real competitiveness. This is reflected in the joint roadmap agreed by the European Parliament, the European Council, and the European Commission, which explicitly identifies EU Inc. as a tool to help companies operate and scale across the single market. At the same time, it's important to be clear about what EU Inc. is and what it's not. It is not a silver bullet. It doesn't aim to address all aspects of the business environment. taxation, labour law, and other areas remain largely national. Remains, doesn't change anything. But this doesn't make the proposal weak. On the contrary, it makes it workable. In a union of 27 member states, full harmonisation across all dimensions is not realistic in the short term. EU Inc. focuses on what can be done now, reducing the most damaging, visible and most damaging forms of fragmentation in company law. Its value lies precisely in being practical, targeted and usable for companies. And for that reason, its design is critical. It must remain simple, accessible and genuinely European. If it becomes overly dependent on national law, or if it reproduces the fragmentation it is meant to address, it risks becoming just an additional layer rather than a real solution. Ultimately, the question raised in this panel is whether such a proposal jeopardizes workers' rights. But I would suggest that this framing misses the core issue. Fragmentation is not a protection mechanism. It doesn't safeguard workers. What it does is limit investment, constrain growth, and reduce the capacity of the European economy to create high-qualified jobs. The real challenge is not to choose between competitiveness and worker protection. The real challenge is to design a system that delivers both, by reducing unnecessary barriers while maintaining strong protection where they belong. EU Inc. is a step in that direction. It doesn't replace national systems. It doesn't refine labour law. It introduces a European option where today there is none. So the choice we face is quite straightforward. Do we accept that the single market remains fragmented in practice? Or do we take concrete steps, even incremental ones, to make it function more efficiently? Europe doesn't lack talent, ideas or ambition, but too often it lacks the ability to operate and scale. EU Inc. will not solve everything, but without it, we will not remove the fragmentation that prevents companies from reaching that scale in the first place. The debate is no longer about whether EU Inc. is needed. It is about how far it should go and whether it genuinely reduces fragmentation or reproduces it. And that's why it is necessary. Thank you, Esther and Julie. And Maxi and Lucy and Maxi also for your comments.
Thank you very much, Antonio. I guess we are going to have a nice debate then after. Let me move to Markus Meyer-Erdmann from ETUC. I understood that you are having a short presentation, so if also you could limit to some 7 minutes so that we can then continue with the debate and targeted questions. The floor is yours, Markus.
Thank you very much, Madam President, for having me, and to Maxi and Mr. Garcia de Rego for your introductions already. So I can be brief with my presentation since I only have 7 minutes. And as a legal researcher, that's quite challenging to stick to 7 minutes. Now, I would like to start with the point made by Mr. Garcia de Riego that we should not choose between competitiveness and worker protections, which I think is a very valid and important point. And my presentation will outline that this should be the goal, but that there are current shortcomings in the EU Inc. proposal that must be overcome to make this a reality. So I agree with you that it should not be a choice. But currently, from my legal assessment, this is not yet the case, and that should be, at a minimum, be addressed to be sound and not a deregulation tool when it comes to labor law aspects. Now, for now, and this has been mentioned by every speaker already, there is no EU-level protection of worker participation in the EU Inc. proposal yet. And the problem here is that, indeed, company law should be harmonized, and there is still fragmentation, what was just mentioned by the previous speaker. However, then company law is the single connecting factor to all other areas of law, to social law, to creditor protection, to insolvency law, and so forth. And if you're harmonizing only one aspect, you're leaving behind all the other aspects. And here we come already with the problem of fragmentation and the threat to workers' rights, because if you're not harmonizing the rest, and the legal basis was outlined by the President already, then we have the problem that we are leaving the other areas of law behind, which leads then to regulatory arbitrage and which can be used as a race to the bottom. Because employee participation rules for now, and I will get to that in a second, they are tied to the registered office of the company, and the split seat approach was already mentioned by Maxi in her presentation. And that leads then to a choice of law where an EU Inc. can register in any one of the EU member states, say in the Netherlands, but then the actual economic activity is in another EU member state. And then you have a decoupling of the actual activity of the company and the registered office. While this is allowing for flexibility, yes, but that leads also to regulatory arbitrage and cherry picking. And since the 70s, we had lots of EU directives and regulations that were harmonizing, for instance, the SE directive, which was a blueprint that could be used here, where you're accompanying the labor law safeguards with the regulation harmonizing the company law aspects. So this departure from that is creating many of the problems that I'm outlining in the remainder of my presentation. And crucially also, there's no limitation of the scope. It was mentioned by Mr. Garcia de Rego that this is meant to be for innovative companies, for startups and scale-ups. However, right now, every company, every multinational, even stock exchange listed companies, and Wirecard was mentioned as a gross misuse of our corporate governance frameworks, then since there is no limitation of the scope, I have to be critical of all the possibilities that this can be abused by any other company that is not an innovative company and not a startup company. And you can use this as a holding company, as a sub-holding company. You can chain indefinite amounts of EU Inc. companies to stay below thresholds, which I will mention in the next slide. And this can be abused. Yes, it can be used, but it can also be abused. And especially the 48 hours, not business days, but working day, or days in a week, that leaves no preventative checks that are necessary for corporate governance, and that is also in the interest of good actors who want this framework to be successful. And shelf companies, we see that our research covers all SE companies that were created ever in the EU. I'm tracking that together with many colleagues for the last 10 years at ETUC, but also at university where I'm also associated. And we see that the vast majority are shelf and letterbox companies. Now, the conflict of law rules that are currently included in this proposal, which is the Rome I regulation, which was also outlined, and we have Mr. Repasi here, and probably he will speak about this later in the panel, that protects the individual labor rights. And that is a key element to protect individual workers' rights. But collective rights, such as collective bargaining, information consultation, and board-level representation, is not covered at all in the Rome I regulation. So if the recital of the Commission proposal relates to the Rome I principle, that only covers individual, not collective rights. So that's a major shortcoming already. And specifically, Article 4, subparagraph 2 of the current Commission proposal, I would like to outline. Now, it was mentioned that this should, and also Mr. Garcia de Rego pointed to this, it should be only a company law aspect. However, as it reads right now, that any other area of law that is not covered by this regulation or the Articles of Association shall be governed by the national law where the registered office of the EU Inc. is. So that departs from the Rome I principle that where the place of work is, for instance, that those labor rights should apply. In other words, if you register an EU Inc., say in Ireland, then from the reading of this article in its current form, Irish law would apply to me, despite the fact that my workplace is here in Brussels. So that would mean that we are no longer having this core of rights protected, and this is a major shortcoming of the current proposal. And as I said, the collective rights are not protected, and it makes it also in practice easier to evade, because that's the next point. There is and I'm skipping point 5 for a second, but point 6 is also basic information on workers' rights are not to be provided by the company, especially when it comes to branches in the current Article 40 of the proposal. And then if you're registering branches and you don't have to provide information, then trade unions or labor inspectorates or researchers or any other interested civil society organizations cannot track what their economic activity in that second member state is. And that makes it easier to evade, but also more difficult to organize collective bargaining, for instance, at a workplace. And the once only principle is good in principle and also should lead to transparency. But in the current form, how it is framed, it's limiting the enforcement and data governance policies. In Article 12 was already mentioned that board-level employee representation is currently tied to the registered office, and this can be circumvented altogether. Now, this shows that in the map, the green countries that have a form of board-level employee representation, these countries are at risk if you're choosing simply one of the red countries for the registration of the EU Inc. company, and you can evade, for instance, board-level representation altogether. And there is many varying thresholds. So it's not just a German problem with high levels of employee participation, but also other member states are at risk. And our research, as I said, showed that from the SE perspective, shelf SEs were in almost 70% of the cases, 2/3, were created since the beginning of time, and only about 15% are genuine SEs that are being used and where also employee participation takes place. There are ample examples like Tesla creating a shelf SE with a gigafactory of 9,000 employees, and then you have zero board-level representation in that company, and the Works Council, for instance, is also stacked with management representatives. So that's a gross misuse for me of EU law for the circumvention of national protection regimes. So thank you very much for your attention, and I look forward to questions.
Thank you very much, Marcos. I mean, all your points were extremely clear, and in a way we should be rather debating how to approach it and how to come up with some solutions that would be simple enough and doable enough not to erode the workers' protection we are actually having. I mean, I think we now could make some targeted questions to the speakers. At the same time, we are aware we would like to leave enough space for a debate with the audience. But starting with Maxi, basically, you already talked about the separation of the registered office and the actual management seat. Is there a way, Maxi, to ensure the co-determination rights to be safeguarded under this model?
Yeah, thank you very much for the question. I think under the proposed model, it will be really hard due to this possibility to split the seat. Maybe one point on the possibility to split the seat. It is differently done within the regulation for the SE. So there is the possibility within the SE regulation for the member states to have the unity of seat. And I know that this is a controversial issue because there are some states which have the company law tradition that there is the possibility to split the seat. However, there are other member states where there's actually, from a historic point of view, the tradition of the unity of seat. So I think when it comes to regime shopping and avoiding the possibility to establish regime shopping within a corporate governance and within European company law, this is a crucial point we actually need to address. And I think the unity of seat, of course, would not be the only point we actually need to address, but I think it is a substantial point where one could establish some safeguards. And also when it comes to shelf companies, which have been addressed by Marcos, I think it is in a very important point. I mean, there are many companies which act in good faith, but there are some companies which don't. And these companies have a major effect, and there's also the potential for criminal activity, At the moment, we also talk about, for example, the issue of sanctions, which need to be ensured that they actually are respected from all companies. From my point of view, this is really a crucial point, however, not the only important point from a worker's perspective. And also from my point of view, although we have not discussed within the study group, but from my point of view, it's also a matter of civil society in general, as it is not only relevant for workers, but also for other stakeholders and for the public as a whole.
Thanks a lot. Let me still go to you.
Oh, so you're going to next section?
No, I'm just going to do it completely with her.
Okay.
Don't worry. Just basically on a slightly different note, do you think there could be some mandatory safeguards, such as minimum capital requirements, for example, or stricter identity verification, without undermining basically the goal of supporting startups, which I'm putting to you, should be putting to Antonio, but let's mingle a little bit, you know?
So from my point of view, I think there could be, of course, a way to have like this more balanced approach, which I mentioned. And I think actually, also from a strategic point of view, it might not be the right approach also from the European Commission to just focus on one stakeholder group within this proposal. So from my point of view, actually the EU and also the single market is also is strong or has the possibility to be strong because different stakeholders are actually included. And it's, as I said, it's not an obstacle, but actually it's an asset to work on common solutions. And I think this is actually what we do here in our committee. I mean, this is the strength of the EESC to work together and find solutions not only from one perspective, not only from the workers or employers' perspective or the other different civil society groups, but to work together. And I think it would be possible to have checks and balances. And I also want to underline that certain rules are already established within the EU. For example, with the existing digitalization of company law directives, which already have been adopted. And I would also like to underline that certain issues, also when it comes to digitalization of, for example, administrative processes within public authorities, it's not only a question of legal matter, but it's also a practical question. And I think we really have to analyze what are the actual problems in the different member states which prevent digital processes within, for example, public authorities. And this is not only a matter for companies, but also for citizens in general. Because, I mean, we all are on some kind of regular basis in contact with public authorities. Maybe if you want to get a passport, if, I don't know, you want to change, or if you need some information regarding your social security matters. I mean, there are different questions. And I think when talking about digitalization and speeding up processes within public authorities, we need to really make a concrete analysis of the issues and problems on the ground in order to find the right solution. And then, of course, we always need to have checks and balances. We need to have sufficient time for compliance checks. And I don't know what your personal experiences within your member states, but at least in Germany, the exchange of data between different authorities, it's not working really well. And there are some homeworks the different authorities in the different member states actually need to make in order to really support digitalization processes within public authorities. But from my point of view, having another regulation or another directive on this matter will probably not speed up the process. Especially if it lacks this time for compliance checks, especially if certain safeguards are not in place. These safeguards are important when it comes to actually avoiding financial criminality, ensuring that sanction screenings are in place, that actually it is really clear who is behind a company, and these checks need to be safeguarded. And we really need to maybe look a little bit more into the detail why certain digitalization processes are not as far as we would like as citizens. And I think this is, it's more complex than just making a law on European level in practice.
Thank you very much. To you, Esther.
Yeah, Tony, if I can, just before I ask the question, if I can set it up by explaining something, and in the spirit of having a dialogue to understand, yeah? So, the way in which European employment law directives work is that they set a minimum threshold of decency, below which any member state is not permitted to go, but that it's normal and desirable at national level that the national laws would give more rights than the minimum, and collective bargaining would give more rights than that minimum. And the reason I think that concept seems to be entirely missing in the discussion on the 28th company regime. And that brings me to my question, which I know is on the list, which is, so much of the enthusiasm behind the 28th company regime is this register once idea. And what's not clear to me is that, do you register once, for example, in Belgium, and that's it? Or do you register in Belgium and then you're automatically registered as an employer in Ireland, in France, in Germany? And if that's the case, how would the labour inspector know if you really are an employer in Ireland, or would the labour inspectors not be running around looking for companies that are an employers because they're registered as an employer in Ireland, even though they actually aren't? And I'm not being like smart asking those questions. They really are trying to understand this register once. And of course, that also would apply for social security and taxation, but that is mentioned. Social security and taxation is mentioned in the draft regulation, but registering as an employer isn't. So if you could just, like, as I said, just in the spirit of understanding, how do you see those two questions? The fact that the employment directives shouldn't be considered as fragmentation because, the directives themselves say have, build on this at national level and also through collective agreements do more than this. And then secondly, how this register once will operate in practice when it comes to employment law.
Lucy, respond? Yeah. Well, I will try, because obviously you mentioned this register once and the automatic registration in a different member states. That is based on the BRIS proposal that is included in the proposal, which in our view is an incomplete proposal, an incomplete part of the proposal. Because at the end of the day, what the BRIS does is to put together at European level the different national systems for registers, for registration. But at the end of the day, it will be the decision of the host member state to decide whether that company complies with the rules of the EU Inc. And since there is not a complete European definition and harmonization on this particular point, at the end of the day, it remains at the national level the decision whether to incorporate or not the EU Inc. So, again, that's why I said that it's an incomplete part of the once only principle. Number two, most of this discussion, in my view, it is not part of the EU Inc. proposal. It is already the current status quo. It is currently the status quo. A company can set up here and open a letterbox company in a different member state. That is part of the reality today. and there is not evidence that the unity of seat prevents fraud. And the recent jurisprudence on this matter clearly states in favor of the incorporation principle, where the principle that should apply is the company law of the registered member state, in view of the freedom of establishment. And there are two cases, at least as far as I understand, the Uber Searing case and the Daily Mail case, that advocates in favor of this freedom of establishment. So the letterbox issue is an issue. It is debated. Again, there is not evidence that letterboxes are illegal. They are part of the European way of establishing the functioning in the single market. It is used by most of the member states, by the governments of the most European member states that are represented here. Germany uses, I don't remember and I cannot pretend to remember the German name for this institution, that it is used by the government to issue public debt. In the case of Spain, I can tell you that there is a letterbox company in Ireland to issue public debt because it is cheaper, it is faster. Investors understand very clearly in the way in which it operates, and it is legal. So why are we going to demolish letterboxes? Preemptive checkups and checks, most of them done by notaries in Europe. But they are done by notaries in those member states in which notaries exist. Not in every member state there are notaries. Not in every member state, like in the Nordics, the figure of notary doing these preemptive checkups exists, and there is no evidence that in those member states the level of fraud is higher. So I understand that this opens an interesting debate, but that's why I come back to my point. This is why fragmentation is hindering growth, hindering the ability to scale, hindering the ability to scale and to compete. If we want to focus on if we want to focus on those points that try to prevent the elimination, the lowering down of barriers, and to keep the status quo, we will find plenty of them. But I think that the real issue is not to defend the current positions or trying to eliminate those points of the current labour legislation that we don't like or you don't like, using this tool. This tool doesn't go in the direction of labour law. This is a company form proposal.
I think it's always helpful to have the discussions, because then you can begin to get clearer on where the opportunities for agreement may be. And for us, we're concerned that the proposal is becoming, instead of it being the freedom to establish, it's almost like the right not to establish. And that will create, particularly given what we're here to discuss and the interests of us as representatives of working people, a risk, because at the moment, in particular for labour inspection, the register of the employer is a key building block for the labour inspector to be able to turn up to look for information. It establishes the jurisdiction of that labour inspector for that employer. So there's a lot, from our point of view, riding on it. And I was interested in you said that it's an incomplete proposal, and I think that's our, that's one of the main messages that we have, is that because it's a regulation, you can't rely on it being fixed at member state level. It has to be crystal clear, because often when we get to the Court of Justice weighs up different rights, and so the rights and obligations. So the rights of the employee don't exist without obligations on the employer. So there has to be a clear obligation within the regulation on the employer to register in the member state where the workers are. So that's the current situation. And we would like to see that within the regulation. But I realised I didn't ask you the other thing. So if there was any other point, Antonio, that you wanted to make that I didn't ask you, to give you the chance of, just to give you that opportunity.
Which were the other ones?
No more. That's it, Antonio. Sorry about that. That's you're done now. So am I.
Sorry for being strict, but we still got a question to Marcus, and we would like to have the debate with the audience, so we might get to some of the points, later on. Very shortly, Marcus, we are seeing increasing trend of multinationals using the shelf SEs and cross-border conversions to circumvent national co-determination standards. From a European perspective, does this create a distortion of competition where companies that respect democracy at work are penalized by those utilizing these legal backdoors? And what are the lessons and key takeaways for the Commission's proposal on the 28th regime on that? Thank you.
Thank you very much for that question, and that ties also to the debate that Esther and Mr. Garcia de Riego just had. Now, what we see is, and I was brief in my presentation due to the limits of time, but we published also on this, what we see is indeed that letterbox companies are legal, but it becomes abusive, and that's also recognized by the EU legislator when legislating company law since the 70s, that existing rights that should not be circumvented can be circumvented through the veneer of using EU law, and that's when it becomes problematic. So existing national rights and obligations of an employer can be circumvented due to the fact that labor law in particular and labor law in a corporate context, so in this particular case, board-level employee representation, can be circumvented. You can use shelf SEs. I already showed the statistics, and these shelf SEs are being produced by incubator companies. There are in particular 3 in Germany, 1 in Slovakia, and a few in the Czech Republic predominantly. And they produce thousands of these shelf SEs, and they are then being sold for 35 to 50,000 euros to any buying company, and then they are being activated. And I'm mentioning this because in EU Inc. costs €0 in share capital and €100 in administrative fees. In SE costs 120,000 euros in capital plus these 50,000. So for the price of one SE, you can have thousands and thousands of EU inks that you can create. You can create them with these template articles of association, and you activate them later down the line. And where it becomes problematic is then that these shelf companies are being created with the express purpose of circumventing the before and after principle. In the EU, we have this principle that says that the rights of workers and worker representatives and board-level representation that exist before a transaction should exist after the transaction. And this before and after principle is well enshrined in also the transfer of undertaking directive. That's also important for employers to have a going concern. So all the rights and obligations also that you have an employer and also as a creditor, that you have certainty that what was before the transaction is also after the transaction. That not only goes for employees. Now, and in this context, it's important because what you can do is you have these shelf SEs which are empty. You have no rights before the transaction because this SE is being created empty and then being filled with life. In the case of Tesla, for instance, you're buying the shelf SE. It was an Atrium 175th shelf SE. You buy this off the shelf and you fill it then with thousands and thousands of employees, but they are being deprived of their rights because the shelf SE is being activated instead of converting, for instance, an existing company into this. And with the EU Inc., this can be exacerbated because this once-only principle then also automatizes the transmission of information. And Article 103 of the regulation prohibits the member states from asking more information of an EU Inc. Yes, there is a burden on companies, but for instance, it's no burden to tell the number of employees that a branch of that company has, because you should know how many employees there are. But since the member state is prohibited from asking this information, the simple info, it deprives then subsequent checks and balances down the line. And also with the registered office, and here unity of seat is important because it's not the reality that we have already, that a company can be mobile across the EU through cross-border company mobility, because there are then checks if you're moving to that member state. There is a pre-transaction certificate that has to be issued from the departure country and a pre-transaction certificate issued in the country of destination. So there are two authorities that are involved in these checks. But if you're creating EU Inc. ex nihilo, you then fill it with life. There is no more checks in the meantime, unless you're changing the Articles of Association. But anything related to employment is not addressed in that aspect. So there's ample room for outmaneuvering through EU law, national safeguards and roadblocks that are there for a reason, because otherwise you have a race to the bottom. And that's also not in the interest of legitimate EU Incs., because then the bad actors, they are driving down the status quo and make it difficult for proper companies to function in the European Union. And we as society then pay the price, because there is this cost of failure being cited. But if they can also very fastly create these letterbox companies or shelf EU Incs., close them down, open them again, and so forth in a rapid succession, we as society have to pay the price for that, because employees, their rights are then being deprived, and we have to pay then Social Security, for instance. Thank you.
Thanks a lot for this explanation. So, having heard all the speakers for the moment gives us brilliant basis for a debate. So, I've got already Javier and Angelo. I can see Jack. I can see Florian. I can see Christoph. Aurélie. David. So Javier, Angelo, Jack, Florian, Christoph, Aurélie, and David. Okay. Guys, 1.5, 2 minutes max, because we are still having the second panel. So Javier, really shortly, please.
Pues gracias brevemente a todos, muy interesante. Yo tendría que, dado que la posición crítica sindical se basa en que la propuesta no garantiza derechos laborales y sociales para los trabajadores, haría dos preguntas. A Esther, ¿cree realmente que es posible introducir modificaciones de modo que al final el régimen 28 pudiese realmente garantizar estos derechos o esto es casi imposible? Y Antonio, ¿cómo vería la forma de que introducir en la propuesta las garantías de esos derechos? Y la segunda cuestión, que es más a Esther, para no quedarnos solo en una posición crítica defensiva, ¿sería posible al mismo tiempo lanzar una propuesta sindical coherente de armonización, dado que compartimos los objetivos de mercado único, mejora de la productividad y competitividad, armonización de las normas de creación de empresas, facilitación de esas normas, siempre que no se creen chiringuitos? Creo que sabemos exactamente diferenciar, facilitar una empresa e impedir chiringuitos. Y al mismo tiempo armonizar los derechos laborales y sindicales en el sentido de completar el cuadro de normas básicas laborales y sociales europeas que junto con la negociación colectiva nos garantice que no haya una armonización a la baja. Esta propuesta podría realmente ser la alternativa a una inviable mejora de la propuesta de la Comisión, si es que es así. No tengo a lo mejor alguna duda.
Thank you very much. Angelo, please.
Grazie Lucy. Innanzitutto sono convinto che Maxi e Antonio faranno un ottimo lavoro, perché sono due persone preparate e sappiamo che lavorano bene. Sono totalmente d'accordo con quanto ha detto Javier. Il nostro compito è quello di cercare di fare proposte costruttive in un'ottica europea, proposte politiche costruttive in un'ottica europea. Io ho due domande concrete e puntuali per Marcus. Condivido tutto, Marcus. Due specifiche. Allora, parlavi del diritto di partecipazione, del fatto che esiste un vulnus, perché non esiste una normativa armonizzata a livello europeo. Però può essere stata una scelta ad hoc da parte della Commissione, nel senso per rispettare anche quelle che sono le prerogative nazionali. Sappiamo che la partecipazione funziona meglio in alcuni Stati, in altri Stati non c'è, in altri Stati funziona molto male. E potrebbe essere uno strumento, la partecipazione, abbiamo alcuni esempi che non ripercorro qui, potrebbe essere uno strumento da parte dei governi anche per cercare di promuovere la partecipazione di sindacati gialli e poco rappresentativi, e qui al Comitato Economico e Sociale ne sappiamo qualcosa. La seconda domanda invece è quella relativa al discorso dei diritti individuali e collettivi. Facevi riferimento al fatto che vengono riconosciuti i diritti solo in maniera individuale e non in maniera collettiva. Anche in questo caso però potrebbe dipendere dalla necessità di trovare un bilanciamento anche con le esperienze nazionali, perché in molti paesi sappiamo benissimo che i diritti individuali sono veicolo per il diritto collettivo. Mi riferisco ad esempio al diritto al salario, all'orario di lavoro, alle ferie, allo sciopero. In Italia, ad esempio, lo sciopero è un diritto individuale riconosciuto in maniera collettiva, ed inoltre abbiamo anche delle norme di carattere europeo, ad esempio la Carta dei diritti fondamentali, mi pare l'articolo 27 o 28, riconoscono il diritto alla contrattazione collettiva. Anche questo è un diritto collettivo riconosciuto dalle carte ed esiste un richiamo anche in questo caso, si esercita in maniera collettiva seguendo quelle che sono le prassi nazionali. La domanda è: può essere stata una scelta da parte della Commissione di agire in questo modo per cercare di rispettare anche le tutele nazionali? È una domanda e ti ringrazio per il tuo intervento.
Thank you very much. Angelo, Jack, please.
Yes, good morning, everybody. If the productivity gap between the US and the EU continues to expand at its current pace, it will jeopardise all the gains of the post-war period, including, incidentally, the welfare state. And it's happening very fast. And we need to recognise that we need to complete the single market. And all of these initiatives are components of that. And I do think, and I won't be popular for saying this, that we need to be careful about throwing the baby out with the bathwater. Because preventing a 28th company regime is not in the interests of the people we represent. Renovating this one, if it can be renovated to address the issues which have been outlined earlier, is in the interests of the people we represent, because it helps in the struggle to regain competitiveness with the United States of America. Otherwise, as Enrico Letta says, they'll be making our laws. And the question is as to whether it can be renovated. That's my question to the panellists. Because let's be frank about it, even long before the productivity race results in the loss of all the gains in the post-war period, including the welfare state, the people who are driving this agenda now pretty much have the capacity to implement it anyway, with the support of the far right, if we place ourselves in the position that we're against everything. Thank you.
Thank you very much, Jack. Florian.
Thank you so much. Well, any production process implemented by a company needs, according to the microeconomical theory, three ingredients: capital, land, and labor. Of course, we can discuss about others, but those are the most important. So we cannot create a framework in which the capital is way too mobile and the labor is not having the same dynamic. And I will give you a concrete example. Romania joined the EU in 2007. It was a problem back then of the dynamic of the production factors, meaning the capital was moving to from west to the east, and the labor from east to the west. We'll have the same situation here with regime 28. And the impact, it will be the deterioration of the labor rights. Why? Because the capital, it will be way too flexible and way too mobile, and the labor not. My question to you is, how do you see the impact of regime 28 on the dynamic of the production factors, especially the relation between capital and labor? Another impact of this, of the regime 28, is that it is creating a competition between what the member state is offering and what the EU is offering, to be honest. Basically, it's setting up a standards, and the member state will follow. In some cases, in Romania, you cannot set up a company with 100 euro and in that amount of period of time. It is impossible. Definitely, the entrepreneurs from Romania will use this type of company. How do you see, and the question is, how do you see the competition between what EU is offering right now and what the member state is offering in terms of juridical type of companies? Then the impact of trade unions.
Thank you. We would like to give our panelists also the time to respond.
The trade union representation process, it will be affected. We don't have enough capacity in order to deal with how the legislation it is in Germany, for example. The trade union movement should work more together because the impact is quite crucial, and we need more capacity in order to deal with this. And to improve the proposal, it was mentioned Article 4 and Article 12. Well, I will mention Article 21, 25, 28, 44 and 52 in order to safeguard a minimum standard for labor. It's not only Article 4 and Article 12.
Thank you, Christoph.
Thank you. I will speak in French. Moi, je voudrais revenir sur les éléments de langage qui ont été employés par pas mal de personnes, à commencer par le commissaire ces journées. On nous explique que ce 28e régime sera la réponse à la difficulté de créer des entreprises pour faciliter le développement des start-up. Moi, je suis désolé, en Estonie, là, on parle de 48 heures. En Estonie, en 1 heure, vous pouvez créer votre entreprise. Donc, réformons plutôt les registres du commerce plutôt que de créer une sorte d'usine à gaz. Le deuxième point, on nous explique que c'est pour favoriser le développement des start-up. Et le vrai problème, c'est la carence du capital investissement, c'est la carence du capital développement, c'est la carence d'outils comme Horizon Europe, là, qui vient d'être voté par le Parlement, plus de 200 milliards d'euros de financement. La carence de ces fonds à pouvoir prêter ou cofinancer des projets. Il faut quasiment un doctorat en bureaucratie pour arriver à récupérer ces fonds. Donc ces fonds sont sous-utilisés. Il faut qu'on réponde d'abord à ce point-là. Après, c'est pas un environnement législatif qui va répondre à ces problèmes de fond. Dernière chose, moi j'étais pendant 15 ans secrétaire d'un comité européen de la société européenne, donc le statut de la Societas Europaea. Je vois vois pas pourquoi on ne mettrait pas une obligation de créer une représentation des travailleurs dans le cadre de ce 28e régime. Mais je rappelle aussi, par rapport au détournement de finalité qu'on a vu, c'est que quand on a créé ce statut de la Societas Europaea, on a vu dans un pays, je crois que c'était un pays de l'Est, tout d'un coup, il y a eu 400 sociétés européennes vides, coquilles vides, avec un statut de représentation des travailleurs pré-négocié par la direction pour pouvoir faire des fusions, des transferts de sociétés par fusion, avec évidemment un cadre de représentation des travailleurs bien plus défavorable que si ça avait été négocié avec la structure actuelle. Voilà les points d'attention que je voulais, ou de vigilance que je voulais apporter.
Thank you, Aurélie.
Thank you. I will speak in French. Merci beaucoup pour ce débat extrêmement important. Moi, je voudrais revenir au point de départ. Le programme de travail de la Commission annonçait un 28e régime de droit des sociétés pour les start-up et scale-up innovantes. Or, Antonio, dans ta présentation, tu as parlé de cet outil comme levier d'harmonisation du renforcement du marché unique. Je pense qu'il ne faut pas que nous nous fassions de faux procès. Je pense que tout le monde ici est pour le renforcement du marché unique et le soutien aux start-up et scale-up. Mais nous savons tous qu'un outil qui a deux objectifs distincts risque de n'atteindre ni l'un ni l'autre. Or, tu disais tout à l'heure, on n'a pas de preuve que dans les États membres où il n'y a pas de notaire, il y a plus de fraude. C'est sans doute précisément le problème de la proposition de la Commission qui, sous couvert de faire un régime pour les start-up et scale-up, fait un régime pour toutes les entreprises existantes ou nouvelles, quelle que soit leur taille et leur secteur d'activité, alors qu'il n'y a aucune évaluation des régimes de droit des sociétés nationaux existants qui aurait permis de faire un benchmark pour identifier ce qui fonctionne le mieux, ce qui est le plus à risque. Et dès lors qu'il n'y a pas d'harmonisation, ça questionne sur le choix de la base juridique de l'article 114 qui prévoit explicitement que c'est à visée d'harmonisation. Là, on crée un 28e régime de droit des sociétés supplémentaire. Et quand je regarde les réactions, on se rend compte que les start-up sont très insatisfaites du projet de la Commission. Quant à l'harmonisation du marché, ça nécessiterait qu'on fasse avancer, par exemple, l'initiative BEFIT, qui est bloquée dans les tiroirs du Conseil européen depuis décembre 2024. Merci.
Thank you very much. And David.
Thank you. Insolvency law has been mentioned several times, and the 28th regime foresees very lightweight procedures and in certain cases even the absence of an independent insolvency practitioner. For typical creditors, employees, social security institutions and banks, this clearly increases risk. So my question to Mr. Garcia del Riego, from a creditor and banking perspective, how do you assess this aspect of the 28th regime? Or the Commission's proposal, and would the weakened insolvency rules alone not lead to higher risk assessment of EU Incs. and ultimately make access to financing more difficult? Thank you.
Thank you very much. So thanks for all the comments and questions. Antonio, there were quite a few targeted to you. We start with you responding to the debate here. Unfortunately, 3 to 4 minutes only for you.
I will try to do my best. To the last comment, to the last question, very important. Banks are not equipped to finance startups. As simple as that. The regulation doesn't incentivize banks to provide debt to a startup, which basically doesn't need debt. What a startup needs is equity. And that comes to another comment made before. I think it was Jack who mentioned, no, it wasn't you, probably it was Florian, the issue of the lack of venture capital. I don't remember who made this comment. That well, I have written down here, but I don't know, I cannot pinpoint exactly who made the point. The lack of venture capital in Europe, it is true. It is very difficult for an investor, as I said, to come to a place where the regulation is so fragmented. Venture capital prefers legal certainty, predictability, and harmonization. With this tool, the hope is to have more access to venture capital coming from the States, because remember, by the way, that 84% of the European startups are financed partially or totally by American capital. Now, more comments. Florian, the three ingredients of productivity and labor capital and land. Well, land is going to be difficult to move, but labor will move to where the work is and where it is better remunerated, and capital will move to where they can find a better investment opportunities. And this is the beauty of the single market, in my view. We don't have time to debate, but this is what I think. Javier, tenemos que encontrar el punto de equilibrio entre la flexibilidad y proteger los derechos de los trabajadores. I said it in my presentation also. Our task and the opinion hopefully will reflect this. A balance between the way to progress and to eliminate barriers. Again, the proposal tries to eliminate the barriers that are already existing within the framework of corporate form. There are 60 different corporate forms legally in place in Europe. Well, what we try to do is to have an harmonized way, an harmonized legal form, safeguarding and eliminating all the circumventing rules or circumventing tricks or circumventing loopholes that we can find. That is the challenge that we have. But to deny that this will facilitate the first step, which is the creation of a company, I think that this is a mistake. There is an attempt to eliminate the existing barriers to create a company. Let's work on that. Let's build upon that one, eliminating all the concerns that are rightly put on the table. I don't want to forget another point. Another point that was made by Angelo, perhaps. This proposal doesn't change what is the existing status quo. That's why I think that the concerns that I hear are more focused on eliminating those aspects of the current framework that you don't like, making use of this proposal. This proposal, it is not about labor law. And if there is abuse, let's fight against that. But don't throw, as Jack very rightly put it, don't throw the baby out with the bathwater. I mean, if there are positive issues, let's defend them. We all have the same interests here, which is to make Europe more productive and a place where the productivity raises. Coming back to the capital venture issue, in Europe, the total capital venture amounts to 0.2% of the European GDP. In the States, it's 3 times higher. Something can be done to correct this.
Thank you very much,
Antonio.
Antonio.
I think that I have something else, but...
Sorry. I hope you can still stay for the next part, so you can then involve yourself in the debate.
I am a member of this category. So
I'm not excluding you or kicking you out,
no.
but you might have had other meetings.
I will plan to stay the whole day.
Even better. Okay. Thanks by now. Maxi, some reflection or some reaction you would like to have shortly, please.
Yes, thank you very much for the debate and also for the questions. Maybe some points I would like to pick up on the different interventions. So firstly, also Antonio mentioned that a lot of venture capital is actually coming from the US. So, and this might also be a point we should maybe discuss about. So how can we ensure more European capital is actually used to invest in European startups? And then we also talk about the Capital Markets Union and also the Savings Union. So I think this could also be an aspect. And also public money, of course. I mean, we also talk about how can we actually use public money, how much public money is actually available, and how can we actually ensure that there is more European money actually invested in European companies and also European startups and scale-ups. Another point I would like to mention that, I mean, there always has been the tension between the integrated single market on the one hand and then labor law and workers' participation, which is still organized and based on law on national level. And this tension has been there for quite some time. I think what we actually need are decent standards on European level, and we also have to ensure that there is no race to the bottom and that European law is not undermining national labor and workers' participation laws. Otherwise, we will lose the people's support for this very important European project. At least this is my view, and I think this also is reflected by the different elections which have been taking place in the different member states. Then I would also like to underline and maybe clarify, shelf companies are legal, yes. However, there is the possibility that the legislator, and I'm also really happy that some members of the European Parliament are here and are also intervening today, there is the possibility for the legislator to draft laws under the treaty. Also ensuring that shelf companies are limited and that their use are limited under the treaties. And you mentioned some ECJ rulings on the unity of seat, which have dealt with national legal forms and the question of the unity of seat. Here we are talking about a European form, and I also mentioned that there is the possibility under the SE regulation, Article 7, to have a unity of seat within the national transposition. So there is the possibility within European forms to have the unity of seat, and I think this could be something where, I mean, we can also discuss in the study group, of course, as this also is a point where we, where I think there are different perspectives on, and I'm also really happy to do that within this committee in order to ensure a compromise and to ensure that we reach a common position. I think there are different perspectives on this file and on this proposal. I think it's important that the different stakeholders are included, the different perspectives are included, and as I mentioned before, this will be my measurement for the proposal and also for the opinion, that the different stakeholders are actually reflected, and that, of course, workers' rights and also rights of other stakeholders, such as creditors, are actually ensured within this proposal, and that there is a balance. And I'm sure that we're able to work on this together in the committee. Thank you.
Thank you very much, Maxi. Markus, your reflections?
Thank you. I try to be brief. So there was a question from Mr. Pagliara. Sorry if I'm mispronouncing your name. I'm doing my best. So I do agree that there should be a prerogative for member states, and the Commission should not interfere in national, individual or collective labor laws or make a choice which rights are to be protected and which are not. What I try to make clear in my presentation is that right now, and that's why I disagree with Mr. Garcia, that I'm not talking about abuses that are existing for decades. I'm talking about the fact that previous EU company law directives always had an anchor saying that without prejudice to national labor and social security laws, for instance, or that the Rome I principle is to be protected. Right now it's only in a recital, and there is no anchor in the operative part of this directive, and Article 4.2 leaves it up to any law at national level, not targeted to company law. I find this a gross oversight. If company law was meant in Article 4.2, then the EU legislator should have been clear that company law is meant, that national company law when it comes to the registered office is meant. But right now the formulation is that any laws of the member state where the registered office is applicable. And therefore, it's not a choice of the EU Commission, but it's also making it very ambiguous, and therefore no individual or collective rights are currently protected under this proposal. And that's why I made this point so sharply, where I'm saying this is not good drafting of the Commission on their part and should be repaired in the trilogue process, because neither companies nor workers would have an interest in legal uncertainty which rights should apply. No company wants to find out 3 years later that some creditor protections in another EU member states are applicable to them if they run into a conflict. So it's neither in the interest also of banks, for instance, to not know which rules apply when it comes to risk insurances, etc. So there's ample aspects that need clarification when it comes to this. And then I agree with you that, Mr. Pagliara, that some member states regulate it on individual level and some on collective level, but specifically collective rights are at risk here because they are not addressed at all in the proposal, whereas individual rights are addressed in recital 16 at least to a certain degree. So that's why I made that distinction. And since case law was cited, so Daily Mail Überseering, I fully agree, but there's also in Polbert a more recent judgment that the Court of Justice says that yes, you have freedom of establishment and freedom to provide services. However, there should be a genuine link with where that economic activity is exercised, and therefore some form of national level protections can be in place, for instance creditor protections or ex ante checks that no money laundering takes place, that no terrorism financing, sanctions evasion, etc. So there is still legitimate interest that are limiting the freedom of establishment. It's not absolute. There are limits to this, and there's ample case law on that. So this should not throwing away the baby with the bathwater by saying, okay, they should have freedom of establishment, but we should also not throw away the checks and balances which are vital for exercising sustainable freedom of establishment in the European Union. Thank you.
Thank you very much. Mr. Yor.
Sure, I was asked a couple of questions. Very happy to answer them. So I'm very, very happy that René Rapazzi is here because his report, his opinion from the European Parliament said that the safeguards that we're looking for should be included. And for some reason, the Commission entirely ignored that. The ETUC said we should have some social dialogue on this, because it's going to impact on employment law. And for some reason, the Commission entirely ignored that. So what I can say is this, with absolute certainty, that if the EU changes from being an institution that supports workers and their rights into an institution that introduces a regulation that undermines workers, their rights, and importantly, their collective agreements, there'd be no support for the EU. Be finished. As soon as the EU undermines employment rights and collective agreements, we saw what happened to the support for the EU in the UK, because it was perceived, and quite rightly so, because they didn't have any means of protecting their sector collective agreements, that the EU was undermining the rights, entitlements and pay of working people. So the only way this proposal has any hope of moving forward without significantly damaging the EU is if it's fixed. If it's fixed. Now, it can't be left only to the trade unions to fix it. That's my message. Can't be left up to us and say, well, if you can't fix it, it's your own fault. This is a problem not just for trade unions, it's also a problem for labour inspectors, member states and everybody who believes in the single market and who believes in the EU. Has to be fixed, because the damage that it will do if it's not fixed is so significant and so severe. I do not understand why there isn't much more commitment to working with us to find the solutions. So I'm very grateful that Lucy, the EESC, is willing to do and be part of that identification of what the fix needs to be. And I hope everybody can hear. This is serious. This is not small technical things. This is serious for the EU. And I'm very frustrated that the Commission took the approach of not listening to the Parliament, of not listening to working people. Then the other point that I'm wanted to raise, because it hasn't come up in the discussion, is this share options stuff. Now, the reason I'm very worried about this share options is because talking to my colleagues in America, what has happened there under a couple of their models is that the companies replace the employment contract with a share options contract. So it's a new form of bogus self-employment. And they do that just through contract law. And so instead of being recognised as an employee, you have a promise that when this company is inordinately successful, some 6 or 10 years from now, we'll pay out on a share option. Oh, but by the way, the employer decides the value of your share when you come to try and cash it in. So we have examples of that from America, particularly being used in the tech industry for engineers and their contracts. So this is why we asked the Commission, and we're asking the Parliament now, and we're going to have to rely on the Parliament and the Member States to fix this, is to ensure that that those provisions on share options don't replace the employment contract and pay. Because other than that, there's every risk that the same bad practices in America will come to pass. And then my final point is, I actually not convinced this proposal does what it says it's going to do for enterprise at all, but that's beside the point. But I also do not buy this argument that the only way that the EU can be successful is to harmonise our employment law, because America doesn't have harmonised employment law. The employment law in California is totally different to the employment law in Mississippi. Totally. Like bigger difference than you even have in the EU. So venture capital is quite comfortable and quite able to cope with differences in employment law in America, and I would see no reason why we should listen to those who tell us that that's what's holding us back here. I think the assessment that it's a lack of investment is the right one. It's not just us saying that. It's all the economic institutions, and it's the lack of patient capital. And that's among the big challenges that we have here. It's certainly not, absolutely certainly not, the employment rights that are available to people either in their collective agreements or in national employment law. And I'm sorry for being so hard on this, but the problem is a big one, and we haven't been listened to. This is not, like we said to the Commission, these are the safeguards that are needed. The Parliament wasn't listened to. So it's a good question. What makes me think they're going to listen to us this time? And my answer to that is that that we will work in the Parliament. We'll work with the EESC. But if it's not fixed, the proposal cannot move forward. It cannot move forward. Thank you.
Thank you very much, Esther. Basically, Esther has to leave throughout the next panel. Therefore, it was a kind of reaction to it. But let me thank to all the panelists for now, and we are moving to the second panel. So, yeah, of course, staying here and going to be active within the debate then later. But I would like to ask, of course, Isabel Sherman, but also René Repassé and Hubert Gams to join me here at the podium. We are staying and representing the ETUC. I can see that, Laura. So, after a reshuffle here at the podium to get the panelists of the second panel here on the stage, we are starting with a video message of Commissioner Michael McGrath, Commissioner for Democracy, Justice, Rule of Law and Consumer Protection, and he has asked him to include in his video message also an introduction to the 28th regime, explaining what does it bring to the table and how it mitigates any possible risks to collective bargaining, labor laws and workers' rights. So let's hope it's going to work.
Dear representatives of the EESC Workers Group and members from the European Trade Union Confederation, good morning to all of you, and thank you for inviting me to address your conference today on the 28th regime. Let me start by setting the scene and explaining the core problem that led to the creation of EU Inc. If you're a founder, entrepreneur or investor in Europe today, you're faced with 27 national legal systems and more than 60 different company forms. This bureaucracy delays setting up, raises costs, complicates scaling and ultimately slows growth. Our union is home to the largest market in the world, the European single market of which we're all so proud, home to the largest consumer market in the world and home to endless talent, ambition, skills and innovation. Yet bureaucracy, unnecessary burdens and corresponding costs are pushing our EU innovators and enterprises to look elsewhere. And let me be clear. We all pay the price for this defragmentation and bureaucratic burdensome layers. Fewer high-quality jobs, less innovation, and too often a decision to set up companies and scale outside the European Union. And this is why the Commission on the 18th of March presented its EU Inc. proposal. It aims to incentivise EU companies to set up and scale up in Europe and inspire those who once looked elsewhere to return and stay. EU Inc. is an optional, digital by default, European corporate legal framework. It gives companies a single harmonised set of corporate rules that they can choose instead of navigating multiple national regimes. When companies are able to grow and scale within Europe, they don't just succeed individually, they create more jobs, invest more locally, and generate broader economic benefits that directly improve the lives of our citizens. So what does the EU look like with EU Inc.? EU Inc. will allow founders to set up a company fully online within 48 hours for less than €100 and without minimum share capital requirements. Companies will submit key information once through an EU-level interface linking national business registers, and over time it will be further developed towards a central digital register. EU Inc. will also streamline the practicalities of business setup, such as obtaining tax identification and VAT numbers without repetitive paperwork. It will support investment and scaling through digital procedures for financing operations and simpler share transfers, with fewer in-person formalities and less reliance on intermediaries. Entrepreneurship is not a one-shot effort. Innovation inherently involves trial and error. EU Inc. therefore supports fully digital liquidation processes. This enables founders to close and restart more quickly and cost-effectively while maintaining legal clarity and predictability. Now let me address the concerns head-on. Competitiveness cannot come from weaker protection for workers. It must come from stronger productivity, better skills and fairer markets. The EU Inc. proposal does not change union or national employment and social laws. This is also stated in our proposal. Those rules will continue to apply in the same way as they apply to any other company under national law. This is true for individual as well as collective labour rights. For example, EU rules on employment contracts fully apply to EU Inc. companies. This means national laws protecting workers remain in place. We have also built in strong safeguards against abuse, including so-called letterbox companies. Founders must be properly verified and checks are built into the registration process. Quick, abusive opt-ins into the EU Inc. framework will not be possible. Existing companies will need to have been active for at least 2 years before they can convert. Many will feel the benefits of EU Inc. Founders will save both time and money through the digital by default corporate procedures and will have better access to talent and investment. Investors will also save money and time through the certainty of common rules and digital procedures for financing rounds. And all of us as consumers will be able to choose to buy goods and services from EU Inc. companies. But I would like to underline one final and important message. We want a single market that rewards innovation and investment while protecting workers' rights and labour standards. EU Inc. creates a simpler business framework, but it does not lower standards. Existing rules on worker protection and participation remain firmly in place. Thank you so much for listening, and I wish you all the very best with your discussions today. And of course, I look forward to engaging further with you on this issue over the period ahead. Thank you.
Thank you very much, Commissioner. In a way, it's a pity you could not have been here with us, because it slightly contradicts what you are saying, what Esther was just saying a while ago. But anyhow, we hope to to have a match of the debate at some point. But I mean, it was important for us to have this framework of the respective commissioner also with us as an input into the debate we are having today. Without any further debate, I am turning to the Deputy Director General of DG Just, Hubert Gams. Welcome, happy to have you here with us. Let's start with the 7 minutes address from your side, because then some questions comes, definitely. So the floor is yours.
Yes, I definitely expect questions after having heard also the end of the previous discussion and panel. Thank you very much for inviting me. It will not surprise you that I agree with my commissioner about the proposal. And I want to use my 7 minutes wisely in providing you with some further details about the proposal, But I think, when we started working on this proposal, it was really our wish to get a good understanding of the main problems that are faced by the different stakeholders. And there are many different stakeholders: entrepreneurs, founders, investors, trade unions, workers, legal professionals, and other stakeholders that we talked to in the preparation of this proposal. What are the main problems that the different stakeholders are faced with? And they're different, and they are sometimes probably even contradictory issues, and I think the debate that I followed and the debate that we're certainly going to have will also show that. But I'm happy, and I have to, of course, disagree with Esther insofar as we listened also to ETUC. We were very happy of the contribution that ETUC did and participated very actively in the consultations. We also worked very closely with the European Parliament, and we have listened also to the own initiative report that Mr. Repasi has put in front of the Parliament. It has been adopted by the Parliament with a big majority. Yes, we are not one point. We did not take it one to one. We didn't take everything, and I'm sure we will come to different points where the Commission went down a different lane. Yeah, but I think there are many points actually that are the same in the Parliament's report and in the proposal. And we're also happy that we collaborated with the work of the European Economic and Social Committee. And the study that you did on the 28th regime was very helpful also for us. What I think was clear from all these debates was that we need harmonized common rules, that we need simple and digital processes for companies to set up and to scale in Europe, exactly to attract European capital. And it was mentioned by before also in the panel. We need to offer something that is attractive also to investors, that European money is not going and is invested in the US of what we suffer from, but that it is invested in Europe to create jobs in Europe and to help the competitiveness of the European companies, so that they exactly can create these jobs. The EU Inc. proposal is one piece in the mosaic. It's a corporate legal framework, an ambitious, I would say, comprehensive corporate legal framework. It's not, a harmonization of everything. There are many laws, including labor laws, that are not harmonized by this proposal, where we do not have the ambition of harmonizing the national labor laws. But I think it is a form that will be useful for startups, for scale-ups. And because we think it's a good idea to offer this form, in addition to the national forms that are there, we want it to be open to all companies and not be limited to some. The balanced proposal that we put, in my view, forward builds on 5 main blocks. First, it provides for digital by default procedures. We have to adapt to reality, to our digital reality. We have to make it easier from the start of a company, during the whole life cycle of a company, but also, even when winding up companies. We need to ensure preventive control, for example, by the creation of the companies, exactly to fight and to avoid, it's one of the measures in the proposal, to fight letterbox companies and abuse of this regime. Secondly, also important, I think, for everybody, every entrepreneur, that we have a once-only principle, that when a company shares information with one authority, these authorities, they are responsible also for sharing this information with other authorities, and therefore providing so that, for example, the flow of information goes to the tax authorities so that the company gets easily the tax identification numbers and the VAT number, that it goes easily, automatically to the beneficial ownership register, which has a very important role also, again, to fight letterbox companies and abuses. And this way, that this information flow is ensured, so exactly that we can also fight, for example, money laundering. We need this common working together of the business registers. That's why we use the business registers interconnection system. And the next point I want to make, the third point, is we need a system that attracts investment. I have already mentioned we want to be attractive to investors, to founders, so that capital is not lost to the US and to other regions. It's not only the US, unfortunately. Yeah, but to be attractive for capital, we need something that makes it also easy to raise equity in a quick and efficient ways. Digitalization plays its role there, of course, but also how shares of these companies can be traded. The fourth element that I want to mention is retaining talent. And the measure that we have envisaged there is to have employment stock options. I have nowhere in the proposal I see any risk that this would replace a contract, an employment contract, as was mentioned also before. I don't see that risk. It is an additional element, but it will not replace that. If I, as an entrepreneur, want to employ a person, I need to conclude an employment contract with that person. But we also know from reality that for startups, it can be interesting to have, in addition to this employment contract, also offer opportunities in the form of employment stock options in addition to the contract as an additional incentive. And the fifth building block is, of course, about winding down their operations, where in the proposal we have learned from what had happened with the insolvency proposal on insolvency law, where the co-legislators agreed that they don't want much harmonization, don't want simplified procedures. We still think that in some cases it might be a good idea to reduce the cost of failure. That's why the proposal includes a simplified insolvency procedure for a very limited number of EU Incs, of future EU Incs, innovative startups, and in certain cases envisages certain measures that would simplify and making the winding down of a company easier. Because I think we will agree that the cost of failure, this is one of the things that hold us back. The cost of failures in Europe is still too big and puts it as a competitive disadvantage with other parts of the world. As regards the impact on labor law and on employees, I'm sure this will be in the discussion, but we have not deliberately have not harmonized national law and labor law. And also because it's a very difficult subject and it's very complicated to try to harmonize labor law in the European Union because there are different approaches among the 27 member states. We stayed away because the EU Inc. provides, it's not the full picture of the 28th regime. It provides a corporate legal framework, and that's one element of a 28th regime. Other elements will come with other initiatives, and some will concern employment and labor, some will concern also taxation. It is a structure. It is a form that is not a European-wide company form. It is a form that will be introduced in the national, a harmonized corporate legal framework that will be integrated in the national legal forms, and that makes a difference. Also, for example, as far as the legal base is concerned. What is clear: national labor law will apply to the EU Inc. companies, to every single EU Inc. companies, the national labor law will apply. And, you know, many things I mentioned that have not been harmonized: wages, working time, working conditions, health and safety, equal opportunities, protection against discrimination, against dismissal. This all the rules will apply fully. Employee participation, we know there are many different systems in the EU, in the national member states, and we have not harmonized this employee participation. But this does not mean that we're not fighting the abuse and letterbox companies. There is preventive control that continues when you want to found such an EU Inc. There has to be an existence. If you want to have a company, you want to change it into an EU Inc. There has to be existence for at least 2 years with annual accounts. So there has to be reality, real life behind this company. What I would plead with all of you is to really look at the various elements. I don't ask you, I know you will not agree with all the elements, but what I ask from everybody present here, and of course the co-legislators, to look at the various elements and to try to come to a balanced outcome that fits the various interests that are, of course, at stake, like they are at stake at every legislative proposal, basically every legislative proposal that we do. We need a balanced outcome, and I'm sure we can get there if we are ready to cooperate and if we together look for pragmatic solutions. Thank you very much.
Thank you. I mean, people are having lots of questions already prepared. Just a small remark: the 28th regime study of the House is the study of Group 1, means the employers, so it's not EESC study, just to make this clear. Okay. René, your intervention, I know you have to leave earlier slightly, so try to stay brief so that you can still respond to some, at least some of the questions, comments of the audience that then come after. Floor is yours. Let's try the 7 minutes thing.
Thank you. Indeed, let's try. Now, thanks a lot for the discussion that we already have this morning, and also for giving me the opportunity to address you. To which extent I will have responsibilities with the EU Inc. legislative proposal will be decided in 2 days. On Thursday morning in the URI coordinators meeting, we are going then to decide on the rapporteurship of the legislative proposal. But there is, of course, the own initiative report out there that indeed, unfortunately, the Commission did not completely take over into the legislative proposal. And we shall then see what to do with this. Let me allow to give 2 preliminary remarks. One of them is populist, the other one is related to my other professional activity. Rightly so, the Commissioner also mentioned the pride that we should have for our European single market, which I still intend to call internal market. And this pride can be shown that our new internal market project is named after an American corporate firm, Inc. I find this difficult, that we want to put all our bets on an American corporate firm that doesn't even exist in the United Kingdom, which is also not a member anymore, which doesn't exist in Ireland, that is actually a member, but has its issues with English, and the same is in Malta. So why making ourselves so small? I don't understand this, except for there might be a certain attempt to please a pressure group. Second remark. I have to do this because in my previous life I was a professor of European Union law. I find the choice of the legal base in combination with the legal instrument daring. You mentioned it yourself with regard to certain choices made here. I can see where this argument comes. We have a judgment of the European Court of Justice on the so-called SCE, where the Court of Justice said the previous article that is now 114 is not sufficient for an autonomous legal form, then it has to be what is today 352. And the Commission tries to avoid to run into this judgment by saying it's actually not autonomous, but is harmonizing. But if that is the case, then we have Article 50 standing there that says that whenever there are certain matters of corporate law, it has to be used. And Article 114 says without prejudice to any more specific legal basis, which is Article 50. And that's the reason why in any corporate law measure that we had in the past, we have always either 50 alone or 50 together with 114. And the thing is, if we do this, then we can only adopt directives, because Article 50 is limiting itself to directives, which was one of the main discussions we had with the own initiative report, wherefore I was very much attacked by the EU Inc. pressure group, because I was then in favor of a maximum harmonization directive in order to have legal certainty. The Commission decided to go for a regulation on 114. For me, this is new land in European Union law, and therefore it is risky, since at some moment of time there is going to be legal disputes between whoever and an EU Inc., and there is going to be a national judge who will refer the question to the Court of Justice asking whether EU Inc. actually exists, because its legal basis is actually in violation with the treaties. So the question of validity is going to be asked at some moment of time, and I find it daring. But I'm here not as a law professor, I'm here as an MEP, and the European Parliament is not the European Court of Justice. And also on the stupid name, I'm not willing to pay one single political penny to change the name. I want to put all my political pennies on getting the relationship between corporate and workers right. So in that sense, I will not enter into this political fight. And by that, I come now to the issues of substance here. Going therefore one step more into the concrete. This proposal also has, obviously, is as a proposal as such, something that we should welcome. Because after now months of omnibuses, whose purpose was to destroy previous legislation, we finally realized that our potential in the internal market is to build something up. Indeed, we should address internal barriers that we have, that if you put a money number on it, it's actually much more in terms of size than any of the Trumpian tariffs that were addressed to the European Union. To do more on the internal market is rightly so. But whenever we enter into the internal market legislation debate, we have always to realize one thing. The internal market is, as first step, a liberalization project, because it looks at barriers between member states and wants to abolish those barriers. But barriers are not neutral. They are not politically neutral. And we have to see that when we look at protection standards, that the protection standards we have in the member states is the result of decades-long, in times even centuries-long, internal discussions between societal actors. In particular, if you look at the labour movement. And in different member states, it came to a different settlement of this discussion, but grown over decades. So if we basically create something at the European level without looking at what is happening at the national level, from that moment on, the European level just takes away all those consensus that were found between societal actors within the member states and replaces them with nothing. And that is where the resistance comes from. Therefore, all good internal market legislation that is not taking the protection standards issue seriously is doomed to fail, as the amount of veto players is just too big. And that is this misunderstanding of the asymmetry of this balance between internal market and protection standards. Therefore, we can only achieve more internal market if we elevate protection standards to the European Union level, as much as certain policy actors might not like it. But we have them, and it has good reasons, because it's the protection of the weaker party, and as I said, there were national negotiation, deliberation processes for decades, and they are ingrained in our societies. And therefore, Esther is right by saying, if this is not taken into consideration, it is an attack of the European Union on those elements that are for societies crucial to function. And we have seen this with the back then so-called Bolkestein Directive, today's Services Directive, that was precisely going to the heart of the battle. And if EU Inc. should not go into a wrong direction, this must be understood. And that is the point why I had some difficulties that precisely this battle, which was the one that took basically 80% of my negotiation time, was not taken on board in the Commission proposal. To address the issue in particular of collective labor rights is a difficult one, since we have, of course, liberal forces that want to get rid of it or don't understand it and therefore don't want it to address it. But simply not addressing it is basically taking the position, namely against it. As Markus Meyer-Erdmann was rightly saying so, the issue of collective labor rights is a corporate law matter. Not addressing it means I'm following the standard regime. And if this comes then together with the choice made of a very broad principle of origin, of the country of origin principle, and therefore we are back to Bolkestein, that is raising, and accurately so, fears. That is raising accurately so fears, and they must be addressed. If not addressed, we will get into trouble. And that is actually also in the interest of the startup, scale-up, innovative companies perspective, because innovation is a tricky thing. Everybody likes to talk about it, but the only thing is in 10 years' time, we know what today is supposed to be innovative, and we can hardly address this. Therefore, innovation needs time to grow, to develop, and we'll see in 10 years' time whether it was successful or not. It takes time. Charlatans only need hours, weeks, or months to do something that is harmful. So if we create an EU Inc. that has too many doors open for abuses or for behavior that undermines protection standards, it will be used. And it will destroy the label EU Inc. forever before the first innovation on the basis of this label is actually creating a success story. In Germany, like 20 years ago, it was mentioned in the previous panel, Überseering Daily Mail, on the basis of this case law of the Court of Justice, we got an invasion of limited companies. That's actually a UK company form, which you could create with £1 of minimum capital. And they were all coming in when the UK was still a member state of the European Union. And after 6 months, 8 months, we had a wave of insolvencies in Germany because there were many charlatans amongst those creating those limiteds. So that as a consequence, any new limited was not able to get even a rental contract anymore because they were not to be trusted. As a consequence, limited died out even before the UK exited the European Union. So therefore, if you have an EU Inc. which is just part of some Cyprus, Dutch, Irish sandwich in order to even further optimize taxes, in order to use the terminology of the Big Four, I would say to evade taxes or to undermine protection standards, it will be used, it will get a bad label, and investors will not like it because they don't want to invest into shady constructions. Therefore, it is also in the interest of startups, scale-ups, and innovative companies to close all those doors. And from a collective labor perspective, what's the matter for a startup company to have those doors closed? There's no problem because they are either too small or they're coming to grow, and of course they want to attract talent. And they won't get the talent if the talent sees my rights are not protected, be it under an employment stock option program or anything else. Those people that are smart, they will opt for an employer where their smartness is recognized. So therefore, this in total makes just more sense to address it and to make it very clear. And then we come to an argument that, in my eyes, is misleading the whole discussion. It is the question of, it is a 28th regime. A 28th regime is actually, from the perspective of those who are subject to rules, a second regime. You choose between the national one and the European one. And therefore, everybody wants that the European one must be chosen, and it's chosen if it's more attractive than the alternative. Therefore, the argument is, let's not make it less attractive than the alternative. The interesting question here is, I understand this argument, but what is the alternative? From the perspective of a founder, of somebody who is setting up a company with an economic activity in the home country, let's say Germany, Is the alternative when you're sitting there, oh, do I create a Portuguese company form or an EU Inc.? Or will it be, do I create a GmbH or an EU Inc.? Obviously the latter, because what does this person know about Portuguese corporate law? So the comparison group is not EU Inc. versus all other EU foreign companies, but the comparison group is EU Inc. versus all other domestic company forms. That is the right comparison group. In particular, if the creation is so fast, easy, and all digital, then it's getting even more attractive to choose it as an alternative to a domestic corporate form. And that changes the debate. Because if you have to compete against a small layer of 1% or 2% of EU foreign company forms that are economically active in certain member states, from that moment on you have the race to the bottom that you cannot actually address properly. If your comparison group is the domestic corporate form, then the debate changes, and I think rightly so. So therefore we have to address the issue of the scope of the country of origin principle that Markus Meyer-Erdmann was already presenting in his presentation. On the matter of the German co-determination, but which goes even further than that.
Try to stop. You are at least twice over.
So I say nothing on the substance.
It's extremely interesting. I would listen to you for hours, but we would really like to get also to some comments and questions from the
Of course,
audience.
if you are interested in any substantive remark, you may ask the question. Now I was just setting the political scenery, because I know the political debates, but I had no time to say anything on substance. I invite you to ask the question then.
And we need to invite you, you know, in the near future. Isabel, ETUC perspective.
Yeah, thank you. Thank you so much, Lucy. So some elements of introductions and, of course, a way forward that could be envisaged to look into a 20th regime that could fly for everyone, and in particular in the full respect of workers' rights, because this is also part, I would like to recall that, of the way the internal market is functioning. It's not just a nice to have or even a cost. It's one of the pillars on which the internal market is based, and it is not the one to get rid of. You mentioned the issue of diversity, and diversity is fragmentations. No, diversity exactly what makes the difference of the European Union in comparison to other regimes. And I think here this diversity has not prevented some big businesses to invest in the European Union. However, those businesses investing in the European Union wanted to do it their way and not the way the European Union functions. Example Tesla, example Amazon. And I think this is exactly where we could see the range of the damages that those businesses, the model of those businesses are using, if it would be extended via a 20th regime. And I think this is exactly where we are at this cross-cutting issue of deciding on whether we expand and we make it accessible to all, or whether we prevent exactly the abuses that indeed those businesses have done in the European Union in abusing or not even respecting, circumventing the national legislation in terms of abusing existing format like the SE, Tesla, for example, it has been mentioned earlier on, or even not respecting the collective bargaining rights, which are fundamental rights, so not just a nice to have, not just pick and choose, or I don't respect it because I don't like it. That's exactly the way if you access the European Union, you do business, and not the way the American should do the business in the European Union. You mentioned it will create jobs. What kind of jobs? Do you want to have the job like in Amazon, where you are surveyed the whole time, where you have no time even to take a break, where surveillance is exacerbated, where your working conditions are nearly done to slavery? Would you like to speak about Uber and the platform workers who, of course, have, thanks to the European Union, protections that was on the initiative and triggered by the ETUC to protect those workers? Otherwise, here, again, the situation is modern slavery. So all of that should not result in opening the internal market to those businesses that are the cowboy out there, and I think this is certainly not what we want. What the 20th regime, which is still voluntary and optional, so this is also something that is not along the line of harmonizations. It's optional and voluntary, so it will be an additional element on the basis of the national setting and format. So be well aware of that. Nothing along the line of harmonizing the national system. Bring something which is totally different than the European model is working on, is indeed the shareholders' power, and we could also speak about supremacy. And I think here we have to be well aware of this model coming in the European Union, giving an open door to what we have alerted about is, of course, against the corporate governance that it is proposed in the European Union and should be respected in the European Union. And of course, it is also an attempt to abuse the issue of employee stock options and to make a direct link with the remunerations. And this is, of course, something that we cannot accept here, to have a share-based remunerations. My question to you, should you have shares that might equal more than 30% of your remunerations, will that help you to pay your electricity bill? Will that help you to pay your rent? Not. And I think it's exactly what we are seeing here, is that there is an attempt to put the risk on the workers in terms of so-called talent, in terms of retaining those talent in the European. They will have those talent to pay a higher risk than any other employees in the European Union, and it is not okay. This is not, the price that those talent should pay to get a job in the European Union. And I think this is back to another example, back in time. And the real problem is not the way workers are treated. It's not the way the social security system is working. It's not the fiscal regime. All of that is indeed this balance that is enabling the cohesion in the European Union. The problem is access to investment. How come that a talented enterprise in the European creating solar panels were not able to find access to investment to keep this solar panel in the European Union? It was not a problem of labour law. It was a problem of access to investment. And this is exactly what is not tackled in this proposal. And putting the burden, putting the blame on the workers and the way they are treated, or even trying to trap them in getting shares, stock options, instead of or in complement to their remunerations, is not something that is acceptable. On the top of creating a shareholder system, which is, of course, dismantling the relationship between the company governance and, in particular, the way workers are part of the businesses in terms of getting informed, being consulted, negotiating collective agreement, being part of the board level representations. All of that will be put into questions. And of course, this is something that is far away from the European traditions and of course the way the European Union is built. So the solution ahead of us is to bring back the 20th regime to what it should have been from the very outset. Something which is tackling startup and scale-up in a certain sector where innovation is key. And here, why is this proposal so not linked to the EU Innovation Act? It has gone, it has disappeared, where it is. So here I think we should bring it back to looking to startup and scale-up, not any businesses, not without any limit in relations to the numbers of employees. All of the rules that we have in terms of SMEs and in terms of, for example, the right to information consultation to workers should be respected along the line of the national legislation. So here, to restrict it, to bring it back to a startup and scale-up for innovation in certain sectors. Not all the sectors are really looking into innovations, and the one currently looking for innovations, the IT sector, in terms of artificial intelligence, what do? They lay off. They lay off. So this is not what we want to support in the European Union. We want to keep the job, you say, and we want to keep the quality job out of there. So all of that, and this is the one proposal to be discussed, of course, is not why do we come back to something which would be a regulatory legal sandbox, something that we would test for a couple of years for startup and scale-up in one, let's say, two specific sectors, on the full respect, with the full respect of workers' rights, with the full respect of fiscal rules, and clearly to prevent any abuse of letterbox companies that we know. More than 68% of the SEs currently are empty shelves SEs, and that leads to, of course, letterbox company. You can just buy something which allows you to do any kind of business irrespectively of the national rules. That should be prevented. So all of that is clearly something that will bring certainly the possibility to test, the possibility to assess whether it works or not, to protect the internal market of a very aggressive way to do business on the basis of a model where, of course, everything is about making profit without the redistributions of that profit to the society. And I think here, not only are the workers very much at stake and indeed into getting the risk rather than to have the fair share of their work, but the whole dimension of how businesses will contribute to society in terms of, for example, paying the social security contributions, their share of the business will also disappear. So the society in itself will get poorer and less resourced in terms of bringing back this necessary investment in the society, in the infrastructure. So here, why not a regulatory sandbox where we would look into one or two sectors only for startup and scale-up to be really defined in terms of not any business, not multinational, not the possibility to organize a subcontracting chain that we know could be endless, and of course where the control cannot be done. Back to you, Lucy.
Thank you very much. So again, very rich and inspiring panelist interventions. Hands up. Aurélie? Philip? Dorte? Christina? I've got Aurélie, I've got Philip, I've got Dorte, I've got Christina for the moment on my list. So let's start with Aurélie.
Thank you. I will speak in French. Ma question va être très rapide. Dans le rapport d'initiative dont M. Repasi, vous avez été rapporteur, vous évoquiez la nécessité de garde-fous pour éviter qu'un 28e régime de droit des sociétés ait des impacts notamment sur les droits des travailleurs individuels et collectifs. Donc à vous et Isabelle Schumann, quels sont les garde-fous qui peuvent être intégrés, comme vous l'avez dit, pour que ce régime puisse voler sans nuire aux droits des travailleurs?
That was clear and straightforward. Philippe.
Thank you, Lucy. Listening to the Commissioner and Mr. Gams, one can almost believe that the European Union has finally found the philosopher's stone. If the 28 regime is so beneficial to the European Union, I wonder actually why it has taken 35 years to come up with this proposal. The problem with the single market is the resistance on the part of politicians to continue protecting their turf and their political agendas without actually removing the barriers such as capital mobility, barriers in terms of transport and energy. Those remain largely unaddressed. So actually, without removing these barriers, the 28 regime is at best a half-baked solution without actually tackling the real problem, as I mentioned. At worst, it could develop into a parallel system which labour inspectorates across the European Union are likely to struggle to detect and litigate abuses. Thank you, Lucy.
Thank you very much. Dorta, please.
Yes, thank you. I mean, being here for the last couple of hours and listening to the discussion, I think there's a lot of confusion when it comes to the interpretation and the understanding of the regulation, especially when it comes to labor law and the Article 4 on the country, what I would say country of origin. I come from Denmark, and I can say Danish trade unions are extremely, extremely worried about this proposal. We have a model based on collective bargaining, collective rights, and we do not see any safeguards in this regulation, on the contrary. And when I hear, especially the Commission representative and also the Commissioner, I don't hear any I'm not convinced really, and I don't see the safeguards in the regulation. So my question to you would be, how can you ensure, how can you prove, safeguard that not just trade unions but also companies in the future will not read this regulation as a country of origin principle? What kind of safeguards can you imagine? Because if it is the case, I know it's not the intention. The President has mentioned that several times. It's definitely not the intention. He also said it's not the intention to harmonize. But if companies also is reading it in this way, we might end up with a lot of court cases, long legal battles because of some maybe legal uncertainty in this regulation. So I hope you can assure me that it's not the case.
Always on the positive side. Christina, please go ahead.
Thank you, dear Lucy, for giving me floor. It's truly a very interesting debate, and I especially would like to say thank you for Isabel. That situation after you introduce such subject become much more clear, especially for trade union. But what I would like to say, I am listening to this debate, and I am thinking that at present we need to understand that our country sits in very different level. For example, if we are talking about Lithuania, that we have a very low standards of social dialogue. We have only 25% employees covered by collective agreements. And what we can do, especially, I can imagine that every country wants to be attractive to investors. And looks like Lithuania, for example. Now we are talking about changes in our labor code. And we are talking that we need to liberalize working time, contracts, and we should make some exception for small companies. That's if you have a company till 10 people, that's you. Any law doesn't work for you. You do what you want. And now, for example, if you are very high level of specialist or employee in company, you have a higher salary than 2 minimum wages in Lithuania, you have here already exceptional labor law. That means employer can keep you for can dismiss you much more easier. It's a lot of exceptional for high quality people and for small companies. That's, if such idea would come, I truly very difficult imagine what would can happen in our countries. And my question is, how about other countries who are a very good example for us, who have a very high level of negotiation, have we every time admire Scandinavian countries, Austria, who have agreements, who have a high membership of trade union, but what would happen to trade union after this? Thank you.
Thank you very much. Christina Marcos, please.
Thank you. I will be brief since I had already time in the earlier panel. I would like to know from Mr. Gums, because you raised it and also Commissioner McGrath raised that for instance, labor rights are not affected by this proposal and also pay, for instance, not affected when we talk about the share options. But where does it say in this regulation that this is not being affected? Because it goes also to the Danish comment just now of the country of origin principle. And as Mr. Repasi kindly pointed out again and reiterated that these safeguards are not there, you are maintaining that they are not affected. But can you please point us then to the places in this regulation where this is the case? Because maybe our reading is wrong, because I think this is where the confusion comes from. And particularly on the point of pay, which 114.2, as you're probably well aware of, then prohibits using this legal basis. However, this touches very closely on that point, and also you mentioned, and the Commissioner mentioned, that also other initiatives will be coming. For instance, 100% telework is on the table. So this goes further in the direction of deregulating the country of origin principle, because that would allow then someone to work 100% remotely in another EU member state. So I would like to square these, and maybe you could elaborate on that. Thank you very much.
Thank you very much. I've got at least 2 speakers still on my list. Rana, when exactly you need to go? How much time? I can wait for those questions. All good. Okay. Good. So, Andrea, and then Cinzia.
Thank you. I will speak in Italian. Innanzitutto mi scuso per il ritardo. Avrei 2 domande sostanzialmente. Credo innanzitutto che sia chiaro quanto un regime societario abbia delle implicazioni dirette ed indirette sul mercato del lavoro e sulla legislazione del lavoro. Sono qui. Quindi credo sia sostanzialmente implicito che questa proposta di regolamento vada comunque a impattare anche quella che è la legislazione del lavoro. Le mie domande sono 2. La prima è questa, cioè come, leggendo chiaramente la proposta, come si intende assicurare, diciamo, un meccanismo effettivo di prevenzione delle frodi, che siano fiscali, che siano sociali, che siano tributarie, con dei meccanismi che abbiano 48 ore di margine e con registri che siano sostanzialmente ancora sottosviluppati. Spesso e volentieri il BRIS, come abbiamo visto, comunque non è ancora pienamente operativo, e le carenze in alcuni Stati membri possono chiaramente aumentare la trasparenza, possano aumentare la mancanza di trasparenza, diciamo, nelle informazioni. Quindi come questo meccanismo può innanzitutto prevenire le frodi, e la seconda domanda è come si evita non solo che chiaramente questo regime abbia delle implicazioni negative su quelle che sono le legislazioni del lavoro, ma anche sul mercato interno e delle imprese, perché nel momento in cui si procede, diciamo, ad una libertà di registrazione ed una libertà anche di operare con appunto delle ancora non chiarissime norme sull'attività, diciamo, di queste nuove società all'interno degli altri Stati membri, come è possibile evitare che vi siano un dumping tra imprese, quindi che vi siano sostanzialmente delle concorrenze sleali non solo rispetto ai lavoratori ma anche attraverso le stesse imprese. Quindi ecco, quelle 2 domande che volevo porre. Grazie.
And Cinzia, for this round, last speaker.
Sì, io continuo in italiano. Volevo fare una domanda a René Repasi, perché chiaramente condivido l'introduzione. Noi qui siamo per la maggioranza sindacalisti, quindi tutte le preoccupazioni relativamente ai diritti del lavoro, quindi Però la questione è, da un lato noi dobbiamo affrontare la frammentazione normativa tra paesi europei, dall'altro è una necessità che noi cerchiamo di attirare il capitale di rischio che investa in Europa e che non porti i capitali europei all'estero. Questa è una necessità anche per il sindacato, perché dobbiamo creare lavoro di qualità qui. Quindi come facciamo ad attirare? Ci sono delle questioni che dobbiamo, sicuramente non deve essere al ribasso relativamente alle conquiste che noi abbiamo fatto, condivido tutte le conquiste degli anni 60, 70, 80 nei paesi dell'Europa occidentale e poi dopo nei paesi dell'Europa dell'Est, quindi tutto questo non deve essere messo al ribasso e non dobbiamo guardare al modello americano, perché è stato detto, noi il modello americano non ci rappresenta. Però qual è la mediazione possibile? Perché oggi noi vediamo che c'è una spinta molto forte e in Parlamento europeo non abbiamo la maggioranza, purtroppo, quindi qual è la mediazione possibile da un lato per affrontare la frammentazione, dall'altro lato per attirare comunque i capitali? A che punto siamo? Questo volevo dire.
Okay, thanks for all the comments and questions. Rene, we obviously start with you because you are the one having the fewest time for the moment. And it's a challenge. We are ending the morning session at 1 o'clock, but there are still 2 speakers to come after you at least, you know, so the floor is yours.
Thank you, which of course then prevents me from reacting to the Commission, but maybe it's good also that the legislator starts first and then the executive can bring in its perspective. I will, let's say, focus on two elements. The question on what sort of safeguards that there are, and indeed the last question on how to attract. I would actually want to start with the latter one, because I believe that is actually core to it. Since under the competitiveness obsession that some have here, the idea how to give it shape is we are more competitive if we reduce the amount of rules that there are, which in itself is a very strange kind of looking at things. That doesn't take away that there are things that need to be addressed, but there is no hard evidence in countries that did cut red tape that this leads to any meaningful growth. So if our competitiveness issue is to be addressed by growth, and also from a social democratic perspective, we need growth, because without growth there is no redistribution. So where does growth come from? It comes from innovation. And if that is innovation, and we have to look at the entire innovation chain, which starts therefore with a proper Horizon program that is putting sufficient public investments into research and innovation at public research institutions. We need then to address how ideas come to markets. That is then the startup thing, and then we need to go for the scale-up, and the scale-up needs a lot of venture capital. In Europe, we have 10% of venture capital compared to the United States, and a lot of European venture capital even also crosses the ocean. So how to address this? There's an issue of capital market union that was already mentioned, which is not part of the EUing proposal, and which is running against the same kind of political counter-arguments that there always are. My own party leader is Minister of Finance, and he says we need to have a capital market union. And when I ask, okay, does Germany give up its resistance on issues of insolvency law, on supervision of banks, on certain issues of tax harmonization? And the answer is unfortunately no. So behind the heading, there is not much coming. But that's the issue of the capital market union. What can EU Inc. now do to this? There are a couple of things that it can do, and that also shows basically where we can find the common ground for it. The first thing is, if you look at the venture capital that is invested within Europe, it is mainly invested nationally. And that has to do with the very fact that a venture capital fund that sees some Bulgarian company form has just no clue what this is about, and is also not interested to find it out, and does not want to invest any any money into legal advice to know more about it. So you just refrain from the investment and invest nationally. So therefore, having a corporate form under which name ever, that is where the investor knows this is following the same set of rules. I know what I'm dealing with. That is increasing the possibility for cross-border investments. And that is basically what EU Inc. Can address. Second one is therefore leading to the question of the insolvency as one of the barriers. It has to do with the length of insolvency proceedings. It has to do with uncertainties about how certain investments are treated in certain member states. Therefore, I do think to look at simplified procedures is worth looking at. To do it in a way as in this proposal, I'm not entirely sure, but I'm not against having it in there. I think it must be better calibrated. There was an ECON report on the Insolvency III directive that I was responsible for, which might show some direction, and I recognize some of the elements that I was putting forward back then in the insolvency debate in this proposal, in particular not running into the trap of eliminating the insolvency practitioner. One element that was not put up by the European Commission, which I think is core, is there is this misunderstanding that Europe should work like the United States of America, that every innovation financing is done by equity. But there are many, certainly startups that are small and medium-sized enterprises that don't like equity because they don't want to have strange funds in their company form. But we basically try to push them towards equity, which they then don't want to take. But much of our economy is actually debt-driven. And when we look at that element, we come also into a strange situation. That was the reason why the Parliament proposed that we need to have a European-wide equity-like debt instrument whose insolvency position is the same in all member states. And then you have an investment vehicle at debt level that everybody would invest into because they precisely know what is happening to this. Unfortunately, not taking up, and we see a repetition of this belief in equity. Third element, there's this unfamous Delaware effect that everybody is looking at. If there's one thing we can actually learn from Delaware, it is that we have highly specialized courts there. So if there is a business-to-business matter running, there is a judgment within months. And in Europe, it can take years depending on the jurisdiction where we are. That was the reason why Parliament suggested an alternative dispute resolution mechanism for B2B issues that is then not addressing labor law matters because that's C2B. So business to business, an alternative dispute resolution mechanism where highly specialized fast decision making can be supported, and that is another element that can attract then capital. So these are all those elements that are partly addressed by the proposal, partly not, where an EU Inc. proposal can do something about attracting capital. On the safeguards. First, there is an easy fix that Markus was already mentioning in his own presentation. Make it clear that the whole proposal is without prejudice to certain rules. Put in the legal text the relationship to the Rome I regulation. But then there is another step. The further step is the one that Esther made in the previous. Law is unfortunately only as strong as the control of its compliance. Therefore, the question of labor inspection, how to access what is the employer's quality is, I think, a blind spot that needs to be properly addressed. If we look at construction sites in our member states, we see that this is one of the major problems that national labor inspection is running into. That even though posted workers directive has certain limitations and other rules have the limitations, but when it is about checking whether those limitations are actually met, you run against the issue of labor inspection. And that is something one should look into. And then we come to the issue of the co-determination. I am convinced, and the debate we also had previously, that Parliament's position was starting on we split the seat. The unity of the seat is one of the issues. And it was previously also mentioned that the Court of Justice in its freedom of establishment case law said there is the freedom, but if there is a legitimate interest and there is a proportionate measure linked to it, of course, you can then also apply domestic rules against a foreign law company form. So there's this openness even at the primary level. So therefore, to basically say, now we make it clear that the EU Inc. is not following the principle of the unity of the seat, but the seat can be split for the protection of public goods. That was the basis that the European Parliament has taken. And therefore, the protection of collective labor rights is such interest, and therefore it is the place of the labor relationship that governs the question of a collective labor law, and by that also the issue of co-determination. This gives an easy solution if two legal orders are at stake. If there are more than two, and we have seen in the presentation that can be with multiple cases, it also needs to be addressed. And then we enter into something that you all know very well. It is the negotiation procedure. The vehicle that we have found to somehow deal with the SE, But then we run into the issue of the before and after principle, which then has to be addressed in order not to have the EU Inc. run into the same issues that the SE is currently running into. But once again, from an EU Inc. perspective, this shouldn't be a problem because we do not want to have strange, uninhabited EU Incs. Laying there for years until they are activated for certain purposes. So therefore, I do believe that can be done. And the third point that the European Parliament has put into it, that an EU Inc. who is registered in one country and economically active in another without setting up a subsidiary or a branch is simply not recognized. So there needs to be some sort of economic activity also in the country of where it is actually coming from, some sort of genuine link approach to address, let's say, the hardcore type of letterbox companies. There's a proposal that is out there from the German government that was developed together with the French government, which was not taken up by the European Commission, that says if an EU Inc. registered somewhere in Europe is, for example, active in Germany and is crossing the 500 employees threshold, from that moment on it triggers an obligation to set up a subsidiary. Once you do this, you have a legal personality to which then co-determination law can apply because it's domestic. That is an idea that should also be looked into if we are talking about creating safeguards. There are other issues, but that would go then too much into detail. That should be addressed, but that is another way of addressing the matter. So there are therefore possibilities for safeguards. The current proposal is not putting any of them into it. And to say if it's not addressed, the problem doesn't exist. Once again, legally speaking, this is simply not the case, as the country of origin principle that is in there makes a choice. And then the result is what you all mentioned in your contributions of what is then happening. The Baltic example as one that is very well known. Therefore, not addressing it is in that sense no solution. We came up with some proposals that found broad support in the European Parliament. Therefore, this will also be the basis for any negotiations on the European Parliament side.
Thank you very much. To you.
Thank you. And thank you for the very rich debate that we're having, which is useful, of course, also for me. I'd like to use my intervention just to react also to some different aspects that Mr. Repasi and Mrs. Schumann brought up. Why EU Inc.? I understand and I laud you for that the name is not the decisive thing. You will focus on substance. I think that's a good idea. I'm sure some other members of the co-legislators will certainly discuss the name. So why the Commission said EU Inc. is, well, it's also a branding. We are in competition for investment. And yes, Inc., we know it from America, but I would lay claim that we shouldn't say that they have copyright on that. We want to create a brand. And at the end, the Commission in its proposal settled for EU Inc. But we'll discuss that. I'm sure it will come up. But it is a brand because we are competing with, where do I invest? And it's important for investors that they know, and it was mentioned before, that they know what this company is, and what it stands for. And there is the advantage of having this company that is understood by 27 legal regimes that is part of the 27 legal regimes. And for example, and it came also up, venture capital now, that we have a problem that it doesn't go cross borders, because it doesn't know. Well, here we offer a possibility for venture capital, for investors more general, that they know what an EU Inc. in another member state stands for, as far as corporate legal framework is concerned. And I think that's important. On legal base, very briefly, it is daring, yes, it is daring, and I think we are in a situation, in an economic situation, in a situation of our competitiveness, where we might have to be daring, And yes, there will be discussions about it. It has already started among member states. Is the legal basis the right one? We think it's absolutely defendable that it's legal. And it comes with advantages that we have it as a regulation, because it avoids, again, options for member states to fragment the internal market, and that's why we chose to have a legal basis as it. And yes, I also frankly admit 352 has the problem, well, two problems. First of all, Parliament isn't really properly listened to. And secondly, unanimity is very hard to be achieved among the member states. And all, it's an entry point for many other discussions that would have nothing to do with an EU Inc. proposal or a corporate legal framework if unanimity is needed. That's why the Commission prefers a legal basis with qualified majority. Article 50 would have been a maximum harmonization directive, would have been an option. At the end, the Commission decided, let's go for regulation because it avoids, the risk of fragmentation in the transposition of the rules. We will have one set of rules everywhere when, not if, when the proposal is adopted. A good proposal, a balanced proposal, and we will clearly also the debate shows that many issues that we have to see. And that's also why, this EU Inc. In addition to national forms, yes, there will be competition that some entrepreneurs will look for, do I choose the national form that is well known, where the courts know what to do with it, how to interpret the rules, or do I go for an EU Inc. because it has other proposals that still some national forms don't have, like, the speedier procedure, fully digitalized procedure. I agree with Isabel that workers' rights are part of the internal market, and that's why we have many initiatives that also address them. But we think in this proposal it's better not to touch them, not to harmonize. And yes, there are examples, companies, by the way, companies that are not the target group for EU to be EU Incs. You mentioned two. You mentioned Tesla and Amazon by name. They're investing in Europe, true, because here is a very attractive market of 450 million consumers. Yeah, they don't do it as EU Inc. I don't think that they would do it as EU Inc. even EU Inc. This would exist. And abuses, whoever does it, big companies, small companies, of course we have to fight for. And I'm still convinced that it's not the EU Inc. proposal that will weaken the possibilities to go after abuses. And I think there are rules in there that actually will help us and will help labor inspectors to be able to fight against letterbox companies and against abuses. I see the situation a bit that, that you see this, but our proposal is a lost opportunity to strengthen that. Yeah? And I say we decided to leave that out of the proposal, and there are other ways to strengthen the fighting abuse. And I don't think, and you also, I think, we shouldn't put entrepreneurs under a general suspicion. Yes, there will be some abuses, and we have to fight them, and I think we keep the possibilities to fight them. But there will also be a lot of entrepreneurs who will not abuse the system. And for them, we also have to, it has to be a system, a corporate legal framework that is attractive. And it's a balance to choose. And at the end, that's why we decided we don't harmonize labor law. And also on the question, it's the important Article 4 about the rules, how we, which rules are applicable, Article 4. And what it means. And we see it clearly, it means that, of course, national labor law and all the and rules on collective bargaining are not inhibited by this. Because we say this is harmonization of the corporate legal framework, corporate law aspects. We try to, you can say, well, why didn't you put it clear in Article 4? We put it into a recital to be clear. You can always say, of course, this is not clear enough. But where does it say that we weaken, that legal law, corporate law, national labor law would not be applicable? It doesn't say that anywhere. Yeah, we say this rule as far as this corporate legal framework goes, that is created by this proposal. that will be created if the proposal is adopted. As far as this goes, and these are corporate law, as far as this, it's the rules that I apply. There are many legal aspects that concern a company that are not covered by this proposal and that will also not be, taken away by this proposal. Access to investment, Isabel rightly identified that as a key element, and that's why you must not look just at this proposal as solving all the problems. It will not. It cannot. There is, and it was mentioned by René, that we have a lot to do on the Capital Markets Union. We call it now Savings and Investment Union. That's, again, terminology. But there is a lot of things that we have to fix there to be attractive. But one element to make it more attractive, to keep, and in particular, not even, attract American investment. I want the European capital, European investment, keep that there. That would already be a huge step in favor of more investments in companies in the European Union. And it's true, our system is very dependent currently on on credits. Companies, when they look for finance, they go to the bank and ask, can I have a credit? This is our system that we have, and this will always be an important element of the system, but we think it makes us less competitive if we don't also tap into other forms of investment, and it's called venture capital, but it's not only venture capital, it's not this, this investment fund that will now look for companies. It's savings that people have, how they invest them or so. Well, do they put them on their savings accounts, or do we help them to also be have safe other possibilities to inform? And we need more than a regulatory sandbox. I don't think that we could limit this proposal for just to some sectors or two sectors, as mentioned. I think we don't have the time for that. The competitive situation, the competitive pressure that we are under from America, from China, from other parts of the world is pretty dramatic. And that's why I think we cannot try out things. We have to also, within certain limits also be bold and take certain risks. And what I don't think that we are risking the protection of workers' rights. There are some safeguards, and I want again to say, if digital, the flow of information, the right information will end up with the labor inspectors and will facilitate their life to look to know where I have to look for, where this company that has no activity here, although the registered seat is here. Then I talk with my colleagues in the other member states. What is happening there? Do they do it? So I think it will be helpful to have this a better flow information that we also try with other proposals, like for example a better way on posting of workers facilitate that and have it the digital. In order to have the information arrive at the place where they need it, to fight abuses, and labor inspectors have to play an important role in abuses that I cannot exclude there will be abuses. Yes, there are already now abuses also. I don't think that we make it worse, and I think there are even some ways where we want to be helpful and where we will be helpful. On the question, Mrs. Anderson's question, we don't change the rules on collective bargaining. So in Denmark, the strong role that collective bargaining will be able to continue. We don't limit that. We don't want it because it's a very important role. We also know that the situation is different in member states. There are different models, collective agreements, collective bargaining, but also in some member states we have other models. And I wouldn't have much hope, frankly, if we tried to put one European model for everybody. I don't think that it would work. So we will have to try that all these models can work and can play their role in protecting the rights and interests of workers. There are different approaches, like it was also brought up by the member from Lithuania. Mr. Meyer-Erdmann, I think I tried to address your question. How to prevent fraud? Like we have to fight fraud now. And what is important for us is that we, and I'm also very frank on that, we don't want the discrimination between national forms of companies and this new form, which will be embedded by this regulation in national law. We want them, and therefore I don't want to discriminate what an EU Inc. has to do in comparison with a German GmbH or other legal forms, the Italian SRL, I think, no, it is or SRL. In Italy. So that's why we say this we leave out of the proposal, and the same rules apply for an Italian EU Inc. like for an Italian other private limited company. And avoiding, I will finish, just checking. On co-determination, I know we discussed, of course, also with the different ideas. And we also assessed this would solve the problem of one member state or of two member states or of some member states, and it would create a problem for other member states. And that's why at the end it was decided we don't go into co-determination, which means that a German EU Inc. that comes to the threshold of 500 in Germany will have to apply the German rules on co-determination. A Danish EU Inc. will have to apply the rules that kick in already much easier at, I think, 35, if my information is correct, 35 employees. And that's the problem also a little bit with this splitting proposal. I would have to split this EU Inc. into many different EU Incs whenever the different national thresholds are achieved in one member state. And we think we didn't think that this was the best way to handle it and to keep the company also attractive. I finish now. Thank you.
I mean, thank you for that. I'm afraid it was not that fully convincing for the audience listening to you on these issues, as I'm usually not committing myself into the debate. Just before giving the floor to Isabel, just tell me what is there in this proposal for workers and employees, because it has been mentioned here by Esther. You know, if we do not deliver, because logically for me it would be with widening and strengthening the rights. This is not there. You said we intentionally decided not to go into that. It would have been too difficult and stuff like that. But with all the risks we are facing now, you know, with polarization, what is there for workers and employees?
I hear a lot that we would lower the standards and the lower of protection for them, and we are not lowering them. Yeah? We do not harmonize. We don't invent new protection in this, because this is not the proposal to do that, in the Commission's views. But it is not that we are opening, you know, the floodgates for abuses. And investments, if we attract investments, if it works, if we have EU Inc. companies that invest in Europe, there is something very important for workers also. There will be growth and good jobs that will be created. And this is also something that we need. Competitive. What is in there for competitiveness for workers? I think it's that we make sure that jobs are created in the EU, because we are at risk of losing a lot of jobs.
Isabel.
Thank you, Lucy. So if it's really the case to create quality job in the European, then put it in the core of the text that indeed it is without prejudice to the national legislations in terms of individual and collective rights of workers. That would protect not only the individual part, which we know it's covered by Rome I, but it will also cover the collective rights that are so important to your eyes. Make this extra step, because this is the only way to guarantee that the EU INCT will not be at the detriment of workers' rights. I think we put enough evidence on the table that the existing situations, and we just take the SE, but we could take many more, are already attacking workers' rights in a way which is not acceptable, and it is not ex post that we want to solve those problems. We need to have ex ante the non-access or the non-signal to businesses. You can do business the way you want, and after that we will check. Your recourse to labour inspectorate is nice, but with what kind of means? We know that labour inspectors have even little time to make control in businesses in their own member states. Let's take about one sector which is at the top of abuses, which is the construction sector. There is not even a normal regular controls of the fraud that we know in terms of abuses of migrant workers, for example. Let's take the IT sector and the click workers, let's take the platform workers. You know that it is not possible for labour inspectors to make this control ex ante, not when the problems are there. So it's nice words, but we need concrete actions, we need concrete guarantees. And I think here, one example of the challenges that one of the colleagues mentioned, where are we heading at? We are heading at what we call SLAP. SLAP is strategic lawsuit against public participation, so against, indeed, amongst other trade unions in terms of defending their rights. And it's exactly what Tesla is doing in the European Union. It's exactly what Tesla is doing, for example, in Sweden, when, indeed, attacking the right to strike. We know that the right to strike is the last recourse we have when we cannot bargain collectively, when we cannot get the employer at the table of negotiations. So here, don't tell us there will be fraud. There are fraud already with what we know, access to the internal market without the necessary rules that we need, those safeguards. We know them already. So don't create the additional regime that will indeed bring that on the top of what we know already. And it is going not to be the red carpet for investment. It's going to be the red carpet for unfair competition, exactly between the businesses that are in compliance in the European Union with what the rules are and the others, like Tesla, like Amazon, like Uber, like many others. And I think this is not something that we can accept. Look at the competition rules instead of looking at labour law, looking at the banking sector instead of looking at insolvency. You know, I think all of that is something that we clearly have put on the table, where we see no trace whatsoever in the document and not in the recital. Please don't serve that to us. We know clearly that the recital is not something that any court can base itself on in terms of claiming rights. So what do we need in terms of guarantee, Aurélie? I think this is the very valid questions that we need to be have those safeguards in terms that in the text we need to have a sentence in the core of the text saying that it is without prejudice to the national legislations in terms of individual and collective rights of workers. It is in the full respect of indeed the European and national legislations. I just recall that the European legislation is transposed in the national legislations in terms of social directives. Those are, of course, minimum protections for workers and can be indeed extended at the national level. This is the more favourable clause. All of that has to be respected. So we are clearly here along the line of not accepting that stock options are put at the same level as remunerations, and it's going to come via other ways. We have identified that, and rest reassured that we will not accept that this risk is put on the workers whomever that worker is. So creating categories of workers of high salary, talent, and engineers versus others is also not acceptable. I think this is here an issue that we are not willing to buy in. And I do think here that saying that having stock options is something that will bind you to the and have a kind of loyalty dimension to a company. No. I do think that workers, and it's not me, it's the ILO, workers are not commodities. And in that respect, you cannot just say you're bound for 2 years, you can't touch your share options during 2 years, but we can, get bankrupt within a couple of hours or a couple of days, and you will have nothing along the line of what has been promised to you in terms of your stock options. So, these different kind of setting are not acceptable, nor the way shareholders are doing business, dissociating any business to the running, the management of it. And I think here back to the nitty-gritty things of what we need to have is, of course, that not only workers have rights in terms of being informed and consulted, trade unions to bargain collectively and reach collective agreements, we have the possibility and even the right, in the opinion, to be part of the board of businesses. And this is exactly what is at stake for the moment. We are not wished anymore to be at the table of decisions, where exactly our workforce is needed. And guess what? The fairer you will be in terms of even teleworking, I think this is a very important point that Marcus mentioned, 100% telework. What does that mean? Is it something that will serve who? Not the workers, I can tell you. And here, indeed, the issue of the fiscal dimension and the fair share that businesses will have to pay, or should have to pay back to society, is going to disappear. So we're all getting poorer if we don't have those guarantees that businesses have to comply with EU rules and not just do business the way they want. And I'm sorry to say that, but clearly those businesses, in the opinion, that are indeed challenging all of those rules are exactly the ones who want to change the way the European Union is functioning. And this is not acceptable that we are giving in to the pressure of the US in particular, but not only. And the way to remain, or to attract and remain talent in the European Union is to give them access to investment and to adapt the competition rules in which, of course, a small and medium-sized enterprises having an innovative idea needs to be more support than a multinational like Tesla or Amazon or Uber. And I think this is exactly where the decision has to be taken by the Commission to make sure that it complies with the Treaty of the European Union, Article 3. We are in a social market economy. Of course, has to be highly competitive, but that does not mean at the price of giving in workers' rights, because the three aims we are here to do what we do in the European Union, there's three aims. The first one is social progress. The second one is full employment. And the third one is the respect of the environment. Guess what? Tesla. Does Tesla respect the environment? To access the land, to access the water nearby Berlin in setting a big factory? Is Tesla respecting the health and safety of the workers when exposing them to toxic substances while building batteries? Where are the trade unions that could defend and protect the workers in Tesla? Outside, not able to enter the factory. And guess what? Tesla say, hey, I have my own trade unions. I'm discussing with them. So nothing along the line of respecting what democracy at work should be. And democracy at work is one of the fundamental principles that everyone, and not any business, should be above this, that everyone in the European has to respect that. So this is what we are asking the Commission. This is where we were very vocal in all the instances that we have had to exchange with the Commission, and this is why we are so frustrated and disappointed by this proposal. So don't dismiss right away the regulatory sandbox. I think this is a good way forward to test and showcase that it can work in full respect of workers' rights.
Thank you very much. I mean, we will give the wave of applause to both the speakers that are left here. Let me just make really a very few kind of concluding remarks, because you know that in the afternoon we are basically continuing and building on the quality jobs dimension, so trying to link together this kind of approach. I mean, I hope it was a good exchange, Hubert, for you. And the kind of feedback, although it looked a bit emotional and heated, but I mean, what you tried to say, okay, we are not creating no new rights, which I think is false. We are not doing it. You said in this piece of legislation, but it should have been at the same time, because the EU project is really at risk with all the external pressures we are having, so not to be building on our internal cohesion and improvement in the lives of people within the whole EU is just not a good approach. But I appreciate that you are not the person that could be responding to this. But I mean, the whole debate has been just pointing out to potential weaknesses or risks in the proposal, and I guess all of these should be taken extremely seriously, because this room is full of really experienced people that on a daily basis are dealing with failures that happened with the previous legislations on the EU level. They are facing it, and they can see what just is not working, and they've got the, you know, anticipated precaution really high as trade union is defending their members. I hope we would be able to continue in that process in a way that could bring some satisfaction to all the stakeholders, because, I mean, what this debate also showed, it's not balanced. It's not balanced, and we really need what has been mentioned here several times, safeguards, and they are urgently needed. If not being there, I'm afraid it would hardly fly with us. And again, please take it as a kind of serious message. The issue, and that's what Maxi mentioned, the regime shopping, also extremely important, because if we are just giving this, and I mean, Rene and several people mentioned it here, we are just trying to cherry pick a few of the elements from the American system. We should be proud and build and strengthen the European system, because that's what gives us the advantages of having stable, well-developed, well-educated society, which is to a certain degree, I am from Eastern Europe, but is to a certain degree cohesive and have some prospects for the future. So we shouldn't be leaving the educational system, health system, and stuff like that, and think that with a few elements we just could be better and keep the positives of all the sides. For me, Isabel, it shows that we are going the same direction. We are gonna, with the opinion that is under preparation, and in a way, Antonia, wasn't this a great hearing? In preparing the opinion. Are you happy to be participating? I'm sure you are. But in a way, from, I wouldn't say slightly different perspective, but due to the fact that here we need to find a consensus among employers, workers, and the organized civil society organizations, there are different pieces of added value being brought with. So, of course, we are trying to find all the potential risks, but also opportunities in a way. We are not just one-sided. To come to a piece of regulation that would be really helpful. And we need positive stories, as you have seen for the moment. Don't bet too much on our optimism and positive approach, but we still sincerely hope that the process could bring us to agreeable result at the end. So thank you all. Thanks for the very good comments and questions being asked. Thanks again to the panelists here. We are finalizing this part of our agenda. See you back here at 2:30 sharp, as we are starting with the Spanish State Secretary for Labor with the Equality Jobs agenda. Thank you very much.